Testing 1 2 3. Testing 1 2 3.
Great. Call this meeting to order for 2 p.m. Sunshine Orange Task Force. Call roll.
Chair Wolf?
Here.
Chair Wolf present. Member Forsley? Member Forsley? Member Forsley not present. Member Neighbors? Present. Neighbors present. Member Highland not present. Member Yankee?
Present. Member Highland present.
Oh, you are here. Oh, okay.
Thank you.
I apologize. I didn't think you were here. Member Yankee here. Member Stein? Here. Member Stein present. Member Wong? Member Wong? Here. Member Wong present. Member Montalban? Present. Member Padmanabhan present. Member LaHood.
Present.
Member LaHood present. Member Schmidt.
Present.
Member Schmidt present. We have a quorum.
Okay, thank you.
Shall I read remote access into information?
Yes.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency, issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Wolf, did you want to read me?
I will read it, thank you. Also want to add, if you wish to make a statement during general public comment, please press *6. You unmute your telephone to speak. This is for any area regarding that we have public comment. And you can then also press *6 again to mute your telephone once you're done with your statement. We appreciate your self-facilitation on that. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Okay, let's call the first item.
Well, it's call to order, roll call, and agenda changes. I am not aware of any agenda changes. Anybody else? I'm sorry, I didn't hear that.
Any changes or adjustments to the agenda? Okay, seeing none, let's call the next item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force 2021 meeting. These minutes were not approved in June because it was not the correct version of the minutes. However, the correct version is included in today's agenda.
Hey, folks, any changes or adjustments to these updated minutes?
Just a quick question, not on this, but I noticed that the agenda, this is Vice Chair Yankee, had shall the SOTF waive complaint procedures as part of item 1. Is that something we need to do? Or
No.
No, this agenda does not have more than 2 files for the same.
It was originally included because there were more files, but those got rescheduled.
Yeah, we're going to leave that on the agenda anyway, just in case it's there all to form anyway.
got it. Okay.
All right. Continuing minutes. Any changes or adjustments to the minutes?
I have a copy of the minutes if anybody wants to make comments. I can write it down.
Can I? We're on to the June one.
No, May.
May.
Sorry. I'll hold my comment.
Okay. All right. Hearing none, let's open up a comment. Yes, please. Yes, please. Can you hear me?
Yes, just a moment, Mr. Warfield.
Okay. As speak while Mr. Leger is getting ready, just want to announce that during all public comment, you will hear a chime at the 30-second mark when there's 30 seconds left of your testimony period. That way you won't be interrupted with another voice.
Ready? Mr. Warfield?
Yes.
Are you going to tell me when to start?
Go ahead. I said you may begin.
Didn't understand. Thank you. This is Peter Warfield, Executive Director of Library Users Association. Can be reached at Library Users 2004 at yahoo.com. Also at PO Box 1704, San Francisco, California 411-054. First of all, thank you to the chair for making that chime. I'm not sure how it's going to end. Sound, you say, not a is kind of interrupting, and I think that's an improvement. I hope there's concluding sound as well, voice. First of all, I would like to once again request that the correct and not the incorrect contact information be specifically noted as needing to be put into the minutes. I think I give it correctly when I speak it, and that is in the May minutes you have PO Box 1 space 70544. That should be for the digit extension. So it reads 94117 when it should read 94117-0544. I would appreciate if you would explicitly make those corrections and have those in the minutes where it can be clearly understood what the correction actually is. I'd also like, as I have repeatedly said, to have all of that information, as I stated, whenever I make public comment. There's a problem with remote meetings, which is quite a difference from in-person meetings, and that is nobody can approach anybody and say, we'd like to talk about this or that matter with you or an aspect of what you said. It goes both ways. I can't approach others. They can't approach us. I'd also like to have the Library Users Association, if not the contact information associated with my name, and in particular that will come up where our complaint was heard, where it says the petitioner was Peter Warfield. In fact, the petitioner was Library Users Association, and so the write-up should say that Peter Warfield, Executive Director of Library Users Association, said what your minutes say I said with regard to the case. Thanks very much.
Yes, please.
Are you ready, sir?
Yes, I am. Thank you. This is anonymous. I just wanted to say something is wrong with the conference call line. It's very hard to hear Ms. Leger, and sometimes there's various echoes and things going on. That's all. Thank you.
All the phone callers, before we move on, all the phone callers, please mute your lines, or I will do it for you. Press *6.
Comment?
You may unmute yourself if you want to speak by pressing *6 again. Okay, last call for public comment on the minutes for
May
May 5th.
1415. Maybe I'm out of order at this time. I don't know for sure.
No, we're doing the minutes for May 5th right now.
Oh, I'm out of order. I'm sorry.
No problem. Okay, hearing no more public comment. Public comment is closed. Is there any further discussion on the minutes? If not, is there a motion? Is there a motion to approve the minutes?
This is Member Wong. I'll move to approve the minutes from May 2021.
Is there a second?
This is Member LaHood. I'll second.
Okay, moved by Member Wong, second by Member LaHood. For all the comments, please call the roll.
Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley? Member Forsley?
Absent. Move on.
Member Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Highland? Member Highland?
Can't hear you. Star 6 to unmute if you're on the phone, Chris. Aye.
All right. Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes from May 5th, 2021 has passed.
Okay, thank you.
You can add Member Highland as an aye. I managed to mute you late.
Yeah, we got it. Thank you.
All right, thank you. Thanks.
Let's call the next item.
Item number 3, approval of the minutes from the Sunshine Ordinance Task Force June 2nd, 2021 meeting.
Okay, any changes or adjustments to this?
I have one.
Member LaHood?
What is
Yes.
it?
I noticed in the June minutes that the library users 2004 email address should be at yahoo.com, not at gmail.com. I think this might have been copied from a previous incorrect version.
No, I got Mr. Warfield's email asking me to correct the May and June minutes, and I did that in the system.
They're different. One says Yahoo and one says Gmail.
Yeah, I know.
Okay.
So which is the correct one?
The one in the agenda in the packet is not correct. I heard from Mr. Warfield, I believe, this morning, and I made the change.
Okay. As long as you're aware of it. Thank you.
Yeah.
Okay. Any other changes or adjustments? Okay, let's move public comment. Public comment.
Yes, please. Can you hear me?
Yes, just a moment.
Thank you.
Are you ready, Mr. Warfield?
Yes.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com, as I have said many times before, and also at P.O. Box 170544, San Francisco, California 94117-0544. I appreciate Member LaHood's anticipating or noticing that there was a problem with the email address. I believe there was a problem with the May email address as well previously, but somewhere in its life as a draft document, it may have changed. And I'm a little uncomfortable with changes that are not acknowledged in the minutes. I think the appropriate thing to do, while I appreciate the administrator saying that she has changed this, I looked at these minutes earlier today, and they had the wrong email address. That means they had been published for more than a month with the wrong email address, which, as far as I'm concerned, is worse than no email address, because it means that somebody using it might try and reach us and fail and say, well, I guess whatever they might say and give up. If they didn't have anything, they might go and search for it somewhere. So I would appreciate, and I think it's important, that the correction be done as a correction to something that was published for over a month, and specify what the correction is. I would appreciate that very much. In addition, I would appreciate having the relationship with Library Users Association in every appearance of my name in public comments when I have given it, as well as the contact information, which apparently you don't seem to want to do. But I haven't heard any explanation for why at the full task force. It seems to be a policy or some kind of a thing that is unspoken and not answered when I have requested what's happening. In addition, I noticed that my apologies, it wasn't in May, it was in June that presented our complaint number 20082, library users against the Library Commission. And so where the minutes on item 5 say Peter Warfield's petitioner, no, the petitioner was the Library Users Association, of which I'm the executive director, and so it should say Peter Warfield, executive director of Library Users Association, provided a summary and so on and so forth. So other than that, that's all that I have time for, but I think that should do it and make the minutes accurate and documented and voted on. Thank you.
Do we have other public comments?
Yes, anonymous, please.
You ready, sir?
I am.
Go ahead.
Thank you very much. This is anonymous. I think that you should not use anonymous, anonymous number 2, and anonymous number 3, just like you shouldn't use male anonymous versus female anonymous. The trying to guess whose accent is who hasn't actually been accurate in the June minutes. So I think you should probably do what other commissions do, which is just say, anonymous speaker said this, anonymous speaker said this, or make it accurate as to who is who in that minutes. But I think that would be very hard, and it requires guessing whose accent is whose. So I think it should just say, anonymous speaker said this and that, because there were at least 3 of us. And right now it's not correct or consistent. Thank you.
Please call for any other public commenters.
Hi, this is Mark Price-Wolf with the City Attorney's Office. I wasn't able to join the meeting via Teams. I don't know, I didn't get an invite. I just wanted to let you know that I'm off the call and listening.
Okay, thank you. Mm-hmm. Okay, last call for public comment. Okay, hearing no public comment is closed. I just want to respond to the last speaker with regards to seeking to trying to identify who anonymous speakers are. What any one or another commission does in their practice is no bearing on what we do here to assure compliance or reasonable process. There's no law or rule providing specifics on this aspect. Plus, the Sunshine Ordinance requires that there be, quote, each member of the public and, unquote, and, quote, each individual speaker, unquote, with regards to public testimony. The ordinance reads in Section 6715 as follows in paragraph A, and I'm leaving out the part of the Board of Supervisors requirements. Every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body of items of interest to the public that are within the policy subject matter jurisdiction, provided that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by Section 67.7E of this article. Paragraph B, every agenda for special meetings at which action is proposed to be taken on an item shall provide an opportunity for each member of the public to directly address the body concerning that item prior to action thereupon. Policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B are carried out, including but not limited to regulations limiting to total amount of time allocated for public testimony on particular issues and for each individual speaker. Each policy body shall adopt a rule providing that each person wishing to speak on an item before a body at regular or special meetings shall be permitted to be heard once for up to 3 minutes. Time limits shall be applied uniformly to members of the public wishing to testify. So I don't agree with the blanket labeling of just anonymous for all unnamed speakers without being able to distinguish between the multiple speakers which we require for the minutes and under public testimony rules of state and local laws here in the Sunshine Ordinance part, which I just read. One voice, one individual, one opportunity to speak on any single item at a time. In order to keep track, we need this distinction. So there has to be some delineation because many times one speaker does not want their person to be related or their statements to be related to somebody else's statement. Not all. So if you're naming everyone anonymous, then there's no distinction. And how do we tell which anonymous is reacting to another anonymous's comments? Not all anonymous speakers speak for each other. We cannot discern by their name, or if we cannot discern by their name or some label, and as this particular anonymous stated as in the public comment, and in a email message to myself and to Vice Chair Yankee and to Administrator Leger, quote, should not distinguish by accent or voice, especially erroneously, unquote. Then by name, it must be. It's the only other way to distinguish between one speaker and another. So if we're going to keep claiming or notating that it's an anonymous speaker, there must be some way of distinguishing by some description, like a number or letter. If a person doesn't want to be identified by their accent or voice, then they're free to enter their comments in writing. If there was no recording, then the accent and voice would truly be unidentifiable. But since these are recorded audio public meetings and we can hear voices, and as we all know, there's no guarantee of anonymity in public meetings or in public spaces, then one has to make a decision as to whether to reveal themselves in person, by voice, or visually. This can only go on so far within reason, and in order to be able to continue to run our meetings smoothly. So if the task force wants to overrule my position on this, then let's put it on the August agenda for discussion and possible action. Any other discussion on the matter? Okay, hearing none. Let's call roll.
We haven't got a motion.
Oh, we need a motion. Sorry. Is there a motion to approve the June minutes?
So moved by Member Highland.
Is there a second?
Member Wong, I'll second.
Moved by Member Highland, second by Member Wong. Any further commentary? Hearing none, please call roll.
Member Highland?
Aye.
Member Highland, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan? Aye. Member Padmanabhan, aye. Member Neighbors? Aye. Member Neighbors, aye. Member Stone?
Did you say member Klein?
Yes, I did.
Sorry, I cut out. Yeah, aye.
Aye, okay, great. Thank you. Member Forsley, is she present? Member Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the June 2nd, 2021 task force minutes has passed.
Okay, thank you. Please call next item.
Item number 4, file number 19145, hearing regarding request for reconsideration, complaint filed by Chris Kohrs against the Police Commission to the task force found that the Police Commission did not violate Administrative Code sections 67.5 and 67.21 for failing to respond to a public records request in a timely and complete manner. Shall I read the preamble, sir?
Yes.
Okay. April 7, 2021, the task force found that the Police Commission did not violate Administrative Code sections 67.21 and 67.5. On April 29, 2021, the petitioner emailed the request for reconsideration within the 30-day requirement. On May 25, 21, Chair Wolf requested that the matter be reviewed by the Compliance and Amendments Committee before going to the task force for reconsideration. On May 25, 2021, the Compliance and Amendments Committee found that based on the lack of new information, the committee recommends that the task force deny Chris Kohrs' request for reconsideration.
Okay. CAC Chair LaHood, would you like to make a presentation on this?
Yes, I can give a brief overview because I know not everyone was around for all of the. We've had several hearings back and forth on this. So this complaint originally was heard by the complaint committee back in September 2020. This is about Mr. Kohrs. What had a complaint that he had gone before the police commission in a closed session regarding his termination from the police department. He wanted a copy of the recording and a transcript of the hearing, and there was a portion of the hearing which was in closed session. There was a lot of back and forth over several meetings about whether a full recording of the meeting, including the closed session, existed. It was eventually determined that it existed. He was provided ultimately with the recording. However, Mr. Kohrs believes that he was not provided with a complete recording. There's a disagreement about this. The police department says that they have provided a complete recording. Mr. Kohrs disputes this. Nevertheless, as Ms. Leger stated, the task force found no violation, but then this was brought before compliance amendments for possible reconsideration. Mr. Kohrs asserted that we did not and should have considered SB 1421, which covers off-duty conduct, and relates to this issue because he was off-duty at the time of the incident, which precipitated his termination hearing. He was off-duty and he was involved in a car accident. He also says he still disputes the police commission. He still believes that there is that he has not received a complete recording. The police department, Sergeant Youngblood said that they did supply a complete recording, and he says SB 1421 applies to off-duty officers, but that use of force doesn't apply in this instance because it was a traffic accident. We voted on this. It was a split decision. The committee recommended denying the request for reconsideration because there was a lack of new information provided. However, I did not vote with my committee members. So I don't know if Member Neighbors or Member Wong would like to make any additional comment on that, but I think that gives an overview of this case.
Thank you. Other members of the committee, if you would like to add, please do now. Please.
Sure, just briefly, this was my first time hearing reconsideration of the decision. My understanding was that this decision should be made on the introduction of new information. And in my thinking, the argument for SB 1421 as a use of force wasn't satisfactory for that condition. It just didn't meet the terms of new information. And so that was kind of my rationale in that. And I don't know if Member Wong wants to add anything.
Not necessary, but if you want to.
Yeah, nothing from me.
Okay, great. So we'll now move forward with our hearing portion. This is a hearing to whether to grant reconsideration. And the recommendation from the Compliance and Amendments Committee is to deny that. So, why don't we hear from, is Mr. Kohrs here? You can unmute by pressing *6. Not hearing anything. Okay.
Hello?
Yes,
Hello?
are you here?
Yes, I'm here.
Okay. I'll give you an opportunity to address the full task force. I had requested that it be heard by CAC first in case there was a lengthy and extensive amount of discussion to try and narrow down the issues. Considering that it wasn't a unanimous vote, but though it was a majority vote, I'll give you 3 minutes to explain what new evidence that you think might convince the task force to allow reconsideration.
Is there any possibility I can get 4?
Okay, I'll give you 4 minutes.
I appreciate that. Thanks.
Mr. Kohrs, are you ready?
Yeah, I'm ready.
And be sure to give him a 30-second chime. Thank you.
So I give him a chime when his time is up?
No, chime at 30 seconds, and then a second chime when time is up.
Okay. You ready, sir?
Yeah, go ahead.
Go right ahead.
All right. The Police Commission's most recent resolution determining not to release the records regarding file 19145 claims that they have an attorney-client privilege and that they refuse to waive in closed session deliberations. The Brown Act does not, in fact, permit closed sessions for the purpose of attorney-client communications on its own, except regarding litigation. See Roberts v. City of Palmdale, 1993, 5 Cal 4363. Also see Open and Public Forum by the League of California Cities, page 36. Additionally, the new evidence found in Government Code Section 54956.9 states, in relevant part, nothing in this chapter shall be construed to prevent a legislative body of a local agency based on advice of its legal counsel from holding a closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning those matters would prejudice the position of the local agency in the litigation. For purposes of this chapter, all expressions of the lawyer-client privilege other than those provided in this section are hereby abrogated. That's important. This section is the exclusive expression of the lawyer-client privilege for purposes of conducting closed session meetings pursuant to this chapter. So you see the new evidence on page 490. This new evidence further supports that the requested documents must be released, and the and note that the Police Commission has not cited any section in the Brown Act for a proposition to have attorney-client privilege closed sessions outside of litigation matters. Instead, closed sessions have to be held under a specific exemption open to sessions permitted by the Brown Act. More importantly, the Commission did not publicly state the basis for the closed session as a litigation matter. Therefore, the records requested are disclosable. See the new evidence, open and public 5, page 42, as documented on page 491 of the evidence package. Before holding a closed session, the pending litigation exception, the legislative body must publicly state the basis of the closed session by identifying one of the following 3 types of matters: existing litigation, anticipated exposure to litigation, or anticipated initiation of litigation. In this case, it was a personnel closed session citation that was used, not the litigation closed session. And because it was a personnel matter, not a litigation matter, Penal Code 832.7b, SB 1421, explicitly makes this recording publicly disclosable. In fact, the Sunshine Ordinance demands certain boilerplate language to be used to justify each closed session. The SOTF should examine the new evidence contained in the original agenda on page 492 of the evidence packet to realize that this was not an attorney-client privilege litigation closed session, but instead a personal matter closed session. Personal matters are not closed to protect not attorney-client privilege, but with the privacy of the employee. And I waived my privacy rights. As this task force knows, there is no deliberative process privilege in San Francisco, Admin Code 67.24H. This new evidence is documented on page 493 of the evidence packet. Some of the text was cut out due to the formatting issues, so I'll read it word for word. Neither the city nor any office employee or agent thereof may assert an exemption for withholding for any document or information based on the deliberative process. Exemption either as provided by California Public Records Act 6255 or any other provisions of law that does not prohibit disclosure. Additionally, the following is taken from page 7 of Open and Public 5, a guide to Ralph M. Brown Act. This is documented on page 493 and page 465 of the evidence packet. Again, some of the term was cut off, so I'll read it word for word. Generally, public officials should think of themselves as living in glass houses, and that they may only draw the curtains when it is in the public interest to preserve confidentiality. Closed sessions may be held only as specifically authorized by the provisions of the Brown Act itself. On top of that, members must also bear in mind that the Sunshine Ordinance Task Force requires a higher level of transparency than the California Public Records Act and the Brown Act. More reasons why the appropriate transparency must be provided. A few members of the SOTF incorrectly concluded that SB 1421, which requires all records related to certain kinds of police conduct to be released, did not apply to off-duty conduct. Since the Police Commission's own interpretation... Yes? Oh, shoot. Well, thank you for letting me talk for 4 minutes. That's it. I guess I'm done.
Okay. Ms. Leger, we did not hear the chime.
Really? Because I hit it.
Yeah, we didn't hear it, so I'm wondering if your mic, you were muted.
No, I'm not muted.
Okay. Can you just hit it so we can hear?
Did you hear it?
No.
Chair Wolf?
Yes.
Chair Wolf, it might be that the Microsoft Teams is interpreting that as background noise because it's not part of a flow of sound, and so I think it's canceling it out.
Okay. It may not be close enough to a microphone either.
Yes.
So that could be the same. Okay. Well, then let's go back to a voice notice.
Hang on, I'm moving the chime closer to the, I want to see if this works. It's on my, excuse me, it's on my mouse pad.
Can't hear it.
Yeah.
Okay. All right, we'll have to figure out some other way to do it. I thought maybe it would work. Okay. All right. Members, discussion. Or a motion. Or questions for the petitioner for the reconsideration.
I would, Member Smith, I would say that if the law had changed in some way after the prior decision, if there's, say, a new statute, some kind of case law coming out of one of the courts, that would be a real good reason to maybe do a reconsideration. And it does sound like everything that I hear is that it's about what's in the law, and I'm not hearing that there's anything that changed in the law.
I have a question then. We usually don't apply changes in the law after after the date of the case the case has been filed as a complaint, because the law, unless it specifically states that it applies retroactively, all our cases are heard based upon the time that the incident happened. So unless there's some other reasoning to apply a change in law now that would not have applied then, I'd like to hear it. Member Hood.
Yes, I feel like this comes up occasionally, or it has come up recently because we've had a couple of requests for reconsideration. It seems that when in doubt, we have deferred to members of the public in terms of, or not deferred to members of the public, but that we interpret things generally in favor of members of the public when there's a question. One thing that's come up is a lot of people who bring complaints to the Sunshine Ordinance Task Force, especially those who are coming before the task force for the first time, are figuring this out as they're doing it. And, we want people to come prepared, but, the ordinance is complex, and the way things weave together with the California Public Records Act and the Brown Act, and I think often people don't understand everything they could present in defense of their argument until after we've made a decision. I'd like to know actually what my fellow task force members think about the idea that, if somebody makes a case and we make a decision, but then they come back with new information because they've done additional research, if it is truly information that was not considered the first time around, should we give them the opportunity again, or is that, do people need to come to us with a fully formed argument the first time around, and that because they become more familiar with the ordinance and how our process works, should we be giving them a second chance because they know more by the time they've gone through the process? Or is it just, sorry, you have to figure it out the first time around?
Let's clarify what the reconsideration is about. Reconsideration is about bringing any new information that might change the outcome from the original order of determination.
Right.
It could have been subsequent information that had been gotten, and we only give a short period of time for reconsideration. It's only 30 days. Or if there was, usually that is the case, is there's subsequent information that was not part of the original record. It didn't arrive in time or what have you, but the task force went ahead and made a decision one way or another. So, and this applies for both parties. Reconsideration applies for both. So it's not so much a matter of process or necessarily understanding. If a person maybe wasn't sure whether to include a document or a record or not, and then decided not to include it, but then found out at the end of their hearing that that document would have made a difference, that is a perfect reason to do reconsideration and introduce new information that we had not seen yet or not known about yet that could alter the original outcome. If a reconsideration is granted, then we start at the point just before a motion is made. So we're back at a point of debate in considering discovery and discussion before a motion is made. Okay, so I don't know if that helps clarify things based on what you had presented, Member Lloyd. But that is just how the reconsiderations is supposed to work.
Yeah, I mean, actually that does. Based on what you're saying, if a petitioner doesn't include information as part of their argument because they didn't realize that it would support their case, and then we make a decision, but they come back to us later with this information that was not formally presented, that they did not formally present, then that perhaps is something, if we think that it would influence the case, that is an opportunity to reconsider.
Right, correct. Right, Member Schmidt and then Member Padmanabhan.
Yes, just the idea that, and I don't think this applies in this case because I don't see that I don't see this happening, but the idea that someone can say, well, actually, I had some other documents, so I want to come in and try those out. I'm not sure if I could see, unless the rules written very clearly that should merit reconsideration. I'm not sure if I would vote for reconsideration in that situation. But again, that's not what I'm seeing here.
Member Padmanabhan.
I'm inclined to I'm inclined to wonder about what Member LaHood has mentioned. And Chair Wolf, you mentioned an additional document, but additional research could actually form the basis of a document. So if the petitioner has done additional research to support his case, that and could change the way any individual tax members could potentially vote, then I think we should look at it in greater detail.
Okay, thank you. So this is for either party. It's not just for the petitioner. It's for petitioner or the respondent. And I'll just, for everybody's edification, I'll just read from our complaint procedure for reconsideration. Within 30 days of a publication or issuance of order of determination, either the petitioner or the complainant or the respondent may petition the task force for reconsideration only if information exists that wasn't available at the time of the hearing. The petitioning party must present the new information and provide a written explanation of how the new information may change the task force's determination. The task force will accept no more than one request for reconsideration from each party for any specific complaint. That is the basis of the reconsideration. Everything in the rest of the procedure is just how it operates, when it's supposed to when the reconsideration is supposed to be heard, and so on and so forth. But the crux of how a reconsideration, in this case, if we were to analogize it with a court, this would be an appeal of a final original court decision. So, person has 30 days to file a reconsideration or quote unquote appeal of our order of determination, but they must bring new evidence that would change our minds from our original decision. And so that's the question before us today. Any other discussion? Is there a motion? Vice Chair Yankee.
Yeah, just briefly, I guess I'm kind of in a similar spot as Member Schmidt here. I just am not seeing and maybe someone else can point me to it, but I'm not seeing exactly what seems to be new here. I remember a lot of these types of discussions that we had the last time that we heard this case, and I'm not seeing some type of new document or overall new analysis that I don't think we considered last time when this vote was taken. So that's kind of, I guess, where I'm at on this one.
Thank you. Anybody else? Is there a motion? Motion with either...
May I ask Mr. Kohrs a question?
Sure.
Mr. Kohrs, can we hear you?
I don't know. Am I
Yes.
hear my thoughts?
Yes, we can hear you. I have a question for you. So we received these information packets, and they're very lengthy, and it's trying to capture everything that you've presented to us. Can you we listened to everything that you read into the record in your initial 4-minute statement. Can you tell us succinctly, what are you presenting that is different that you did not present the first time around?
I'm presenting the evidence documented on page 499, where it specifically says off-duty conduct is part of, it should be included. This was a personnel closed session, not a litigation closed session. Therefore, it should be released. The commission initially violated the law by saying that the records did not exist. Unless the commission can cite a specific CPRA exemption for withholding the recording, then the records must be disclosed. Pages 511 and 512. These records are a subset of personnel records, and I have a recording of, if you want to hear the actual, statements by the respondent. These are personnel records, and they should be released. The evidence on 469, pages 514 and 515, email sent between Angela Wilhelm and Benjamin Houston, the human resources manager, basically supports this stance. To say that this was not a use of force. Well, I think, when an object crushes someone's skull, traumatic brain bleed, broken jaw, I think that's a use of force. I mean, great bodily injury was sustained by an object slamming into somebody. And I don't see any reason why intent has anything to do with that. A use of force is a use of force. Sure.
Just to be clear, you are presenting this as new information that you did not present in your original complaint. Is that correct?
Correct. All this is new. I mean, I didn't have time to. This is all new.
Thank you.
It would have been helpful to have a kind of a written narrative from you, Mr. Kohrs, explaining all this. I don't see it in the record.
Oh, asshole.
Excuse me?
I believe I did send it. I believe I did send it in the record. But I mean, hey, maybe I'll have to double check, but I feel fairly certain I sent you all this in the record.
Okay, thank you.
Yeah, so please double check. And I don't know who made that comment. That was not me, by the way. So,
okay.
Yeah.
Thank you. Could everybody on the phone please mute yourself? I won't tolerate any interruptions like that. Right. If you're not going to do it, then I'm going to mute you. Neighbors and then Member Schmidt.
Thank you. I think that the request and the spirit behind, Chris Kohrs wanting this information is very compelling, and yet if you're, the definition that you gave us seems to me to be very clear about information existing, and that's not the same thing as analysis or research. It is evidence that exists, right? And this information existed, 1421 existed prior to this, and the other piece of it being that if it turns on the definition of use of force as including a traffic accident, I'm concerned about that interpretation also. But even that aside, whether or not we say use of force does include a traffic accident, to me it still doesn't meet the minimum. We still were aware of this of SB 1421. We were still aware of those details about what the hearing entailed and what it didn't. And to me, it's not the same as bringing in a new piece of paper or missed something that wasn't in the first. It was stuff that we already had access to.
Member Schmidt, I was going to say something, but Member Neighbors said it much more eloquently, and so I will just approve what she said. Thank you.
Bruce, I think you're muted.
Okay, so we're running close to about 30 minutes on this now. I want to try to see if we're coming close to a motion or if you need more information at this point.
This is Sergeant Youngblood from the Police Commission. May I say one thing?
Yes, I'll allow it.
In regards to a use of force by an off-duty
officer. Yeah. Hold on, Sergeant Youngblood. We're not going to re-adjudicate the case. Okay. I'm not going to re-adjudicate it or allow it. What we're doing here is just determining whether there is enough evidence, new evidence that is being brought by the person asking for the reconsideration. If it's new or not, and new enough, whether it would change the outcome. That's all we're doing here today. If we grant the reconsideration, then we'll be scheduled for another full hearing, then we'll have an opportunity to break down all the merits. So, with that, if you have something to add, go ahead.
Then I guess I'm good.
Okay, thank you. Okay, members, is there a motion? Member Schmidt, go ahead.
Well, yeah, as to what I think Sergeant Youngblood wished to say, I think, there is one question, which is there something new here? And then number two is, if there is something new, does it matter? And so I think he would be saying that on that other question, whatever is submitted as new, is it material to changing the original decision? So I'm not sure if what he would tell us would be completely irrelevant to reconsideration.
I didn't stop him from not saying anything. I just wanted to let him know what our process is and what we're making a decision on today. Will we allow the reconsideration or not based upon the new information that was presented by the petitioner party as to whether we, the Sunshine Ordinance Task Force, agrees that this new information may change the outcome of our original decision. It has to be new information, not a rehashing of old information. I mean, it's a high bar, just like any, an appeal would be. So, I mean, it's a very, simple. It's almost, just simple black and white. Vice Chair Yankee.
I guess for the reasons that member neighbors so eloquently stated, I will move to not reconsider this case.
Okay, so is a motion to deny the reconsideration. Is there a second?
You are no longer muted.
This is member neighbors. I'll second.
Okay, moved by Vice Chair Yankee, second by member neighbors. Is there any further debate on the motion to deny the reconsideration? Okay, let's open up public comment. In public comment, it to be pertinent to whether there was new information or not on the old merits of the case. This is only for reconsideration on whether the new information presented. Okay.
Yeah, could I speak, please?
Who's that?
Anonymous, could I speak, please?
Yeah.
Yeah, so I had a question about the new information. So it seems to be a conflict that the person, Chris Kohrs, was saying he did provide new information, and then the people representing this hearing, some of the people that I've heard from are saying that he hasn't provided new information. I just wanted to ask, has everyone on this hearing read through and through the information, all the information that he provided in this last instance? So basically what I'm saying is if all the information the new information that he says he has provided is actually new and it hasn't been 100% read through by everyone in this hearing, then how would you deny this man the right to say that there isn't new information? And so I just wanted to bring that up because I think there should be transparency. And in this case, it just seems like there's something's missing. And I think transparency is very important for the city of San Francisco. And this gentleman seems to really be compassionate about not being able to have that transparency, and it's obviously affecting his livelihood. There's other people on board that seem not to want to be fully transparent or to guard some type of information, and therefore I just wanted to make sure that the information that was served by Chris in this last hearing was actually 100% read through, and that everyone knows there isn't any new information in this before they were to say there's no new information. Thank you very much.
Hello, can I? Do we have make public comment?
Sullivan? Yes, please.
Mr. Sullivan, are you ready to speak?
Sure.
Go ahead, sir.
Okay, so the procedures also say if information exists that was not available at the time of the hearing. So if the information exists, it doesn't exactly say when it has to exist. It just it was not available at the time of the hearing for the people to consider, is what I would read that into. Also want to point out that the reconsideration procedures say information or new information, not new documents or records or new evidence. But it has to be, the person has to explain why it may change the soft determination. But when you guys, I think you guys should stick with the information or new information and not say new documents or records or new evidence. And that's the end of my comment. Thank you for your...
May I speak?
Just a moment.
Have you heard my request, or am I muted, or what?
You are after the person who just spoke. So we have a woman, another speaker.
May I begin?
Yes, you may. Are you also anonymous?
Sure.
Okay. Go ahead.
I am a 44-year resident of San Francisco, and one of the things I like and respect about our beautiful city is the efforts that are made via task forces like yourselves to be transparent in all levels of city government. And this gentleman, Mr. Kohrs, is obviously seeking redress about something that he feels strongly about enough to have done a lot of research on it. And I think, as one of the previous speakers said, hopefully every one of the task force members, every one of you folks, has thoroughly read his latest presentation. And then do you run something like this by a city attorney to make sure that everything is legally accurate? Because I think he deserves a second go-round at this. This is very important that a city agency is possibly not providing information that Mr. Kohrs is entitled to. And it's very distressing to hear that as I listen to this meeting. And I do hope you vote to reconsider his plea and go back and check all the documentation he has given you this time around, talk to the city attorney, and then you can render a full and fair decision. I thank you.
With the speaker.
Is that me?
Mr. Warfield?
Yeah. Let me know when.
Go ahead, sir.
Thank you. Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 1705444, San Francisco, California, 94117-0544. We're not a party to this, and we're not familiar with this. And what I can say is that I appreciate the discussion. I appreciate the sentiments of the folks who brought up the issue of new awareness as well as new documents. So the first thing I would say is that you seem to routinely suspend rules that you have at various times when it's for whatever reason, convenience, timeliness, and so on the top of your agenda, for that matter. The second thing is that there is, and especially as some of the folks noted, for people who are not lawyers or extremely familiar with sunshine law and procedure and so on and so forth, courts were mentioned, and just as something to think about, courts will sometimes, as I understand it, take a statute of limitations and not apply it necessarily to the action that caused the harm, but rather to start the clock from the time that the harm was discovered. So if somebody is spraying near where I live, and I don't notice anything until 10 years later when I'm getting cancer or my family is getting cancer, it's generally understood that there might not have been any way for somebody really to understand what the impact was of the offending actions, in this case of spraying nearby, until there was some other event that happened, which basically means an awareness happened. I do think that that does happen sometimes, and that is something that should be considered. In addition, I've often thought that there may be instances where the delay of an agency in providing information, somebody might want to make the 30 days and may think there is something additional that could be found, or even knows something. If the agency blocks or delays that provision of that information, that might also cause the new information to exceed the 30 days, and so on and so forth. In any case, I think there should be a generous consideration. Thank you.
May I speak?
Hi. Can I speak?
Anonymous?
Which of
Hi, this is Karina. Oh, sorry.
No, go ahead. You're more than welcome to go ahead.
Oh, sorry. I'm Karina Wong. It's true that these are public records, and by law, they should be disclosed. Thank you.
I didn't hear what you said, ma'am. What?
I said Karina Wong, and I feel that these are public records, and by law, they must be disclosed. Thank you.
May I speak?
Hang on. You ready, sir?
I am.
Go ahead.
Thank you. I'll call myself Anonymous number 3 since there's 2 other Anonymouses, and I'll try to use that consistently throughout. So it seems like a large part of the public correspondence, written public correspondence I said, has actually been cited by the petitioner in their opening statement, so I'm not going to repeat any of that. But I will say that your procedure says only if information exists that was not available at the time of the hearing. And so if any of you believe that maybe some of the information about their citations to being attorney-client privileged, even though I don't think it can be, or about how SB 1421 might or might not apply, if you don't think that was available to you, the task force, because I don't think it says available to whom. Is it available to the petitioner or available to each member of the task force? If any of you think that any of that information wasn't available to you, I would urge you to vote for a reconsideration. Thank you very much.
Any other public comment?
Yes, Anonymous, sir. Can you hear me? Hello?
Yes, we can hear you, sir. You want to speak?
Yes, hello.
Anonymous speaker.
Yes, I'm an anonymous speaker.
All right, sir.
Yes, I fully concur with the lady that sometime before made some comments about Mr. Kohrs having major concerns. First of all, to get 3 or 4 minutes to explain the concerns isn't that much time, but I know you have busy agendas. But I read through that topic. To me, there was a whole lot of new concerns there, really relating to the need for transparency. And in that light, I'd love to play a little clip that was provided relevant to transparency and what can happen without transparency. Just a moment.
The doctor and the doctor sitting left with your client. Pardon me? The doctor was in what car? In the car with my client. She was a friend. The doctor and his brother were friendship interests. They were in the car together. And did the doctor get out and tend to go ahead? The doctor I think yes. The answer is he was there and he went to the That's what I know of the case. I also know 911 was called and the police came and paramedics came. Did the doctor leave with your client? He did not leave. He stayed there. He was interviewed by the police department.
But the incident report says that all the occupants left the scene prior to the police officers arriving.
That's not accurate. That is not accurate. I don't know where you got that.
The incident report?
They're saying these people were not there, the weather wasn't there, and the doctor, the passenger wasn't there. That's not accurate. When the police arrived, they both were interviewed. In fact, they talked to the brother, and they wanted to know where he was.
Well, that's one of the reasons why I think we really need all the transparency that we can get. Even right now, the police commission doesn't even want to release the tapes to the SOFT commission. I don't understand that. What are people trying to hide? And I read all of those things that were put into the packet. To me, there is a lot of new information there, not only on the things that Mr. Kohrs got a chance to mention today, but also on going through, the Brown regulations. I don't know the layman. But anyway, we really need to get out of this, to get the transparency, and I fully support having a lawyer, someone read through what Mr. Kohrs had to say in that packet, review it, approve it, and let the people know. The other thing, everyone that's on the SOTF should have read that. Listening to some of the people, I don't think that's happened. Anyway, just my comment. Thank you very much. Bye.
Okay.
Hello. Hello.
Hello, can we help you?
Yes, my name is Naveed Filsuf. After listening, I'm strongly in support of the new evidence provided by Mr. Kohrs to be reviewed before any new vote has been made. It looks like the new evidence is incredibly detailed. A lot of time was spent on it, and I think that at the very least, it should be reviewed so that it can have due process.
Excuse me, sir?
Can you hear me?
Yeah, I can hear you. You said your name and I didn't hear it.
So my name is Naveed Filsuf, and I think in light of how detailed Mr. Kohrs was, I think the evidence he provided on 6/27 should be reviewed before the vote before the next vote is taken. Given how much time he put into it, I think we owe it to him to give him full transparency on this. Is there anything else I can say? Did you hear that?
Yep, we heard it. Thank you.
Thank you.
Any other public comment? Last call. Okay, public comment is closed. Okay, members, any last thoughts? Are we ready for a vote? Okay, please call the roll.
Just a moment. Member Yankee?
Aye.
Member Yankee, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
No.
Member Stein?
Nay.
Member Forsley? Absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
No.
Member LaHood, no. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
No.
Chair Wolf, no. The vote failed because we had 5 yes and 4 no.
Okay. Is there any other motions?
I'd like to make a motion to reconsider this case before the full task force.
Okay, moved by Member LaHood to allow reconsideration. Is there a second?
I will second that.
Who's speaking?
Member Padmanabhan.
Okay. Moved by Member LaHood, second by Member Padmanabhan. Any discussion? Okay, let's open it for public comment.
Hang on a second, Bruce. You are opening this matter up, Lila, for reconsideration.
Yeah, it's just the
I make the motion.
Yeah, it's the other way around. This is to allow reconsideration. Okay, you ready for public comment, Ms. Leger?
Just a second. Okay, do we have a speaker?
Sure, this is anonymous number 3.
You ready, sir?
I am.
Go ahead.
Thank you very much. I strongly urge you to vote in favor of a reconsideration. I think that this case, whether it's intended to be or not, can have a precedent that would harm disclosure of police misconduct files. And if a police claims that they hit someone with a car and it was just an accident and is off duty, and that doesn't count as SB 1421, I think that's very dangerous. And I think that whether or not that's how you intend it to be. And so I think that I will, again, my public correspondence, it seems like, has been read almost word for word by the petitioner into the record, but at least the first half of it. So I would strongly urge you to vote in favor of a reconsideration and actually now consider then these provisions of the Brown Act, whether they properly cited it, whether they properly put the agenda, and now whether they can claim any kind of exemption on that basis. And maybe do additional, maybe consult your DCAs about what exactly is part of SB 1421 and not maybe based on some case law. Thank you very much.
Next speaker. Last call for public comment.
Yes, please.
Hello, this is Naveed Philsuf again. Hello. I just want to make it
Okay, hold on,
clear.
Mr. Naveed. You have to wait your turn, and the administrator, the clerk, will let you know when it's time for you to speak. Let's make sure, because we got a number of people that want to speak here. Let's keep them in order. Appreciate it. Thank you. Ms. Lachey?
I believe Mr. Warfield was the next commenter.
Yes, please.
Go ahead, sir.
This is Peter Warfield. Thank you for the motion, and we certainly are in favor. Basically, if in doubt, if there's any doubt in anybody's mind, I think there should be, as I said, a generous understanding and interpretation. I would certainly agree with what Anonymous has said, and again, a generous and an ample appreciation. I would certainly favor, if anybody is in doubt, having a reconsideration in the interests of fairness, of justice, rather than a closure and a non-consideration. So, supporting the motion. Thank you.
I'd like to speak.
Hold on. We have Mr. Naveed first, and then you.
Thank you.
Hello, this is Naveed Philsuf. Thank you, sir. In the interest of full disclosure, in the interest of fairness, I strongly urge you to support a reconsideration. There was new evidence provided on June 27th by Mr. Kohrs. I think we owe it to him, to our system, to give him his fair shot. And I would like for a reconsideration to happen so that he can have his due process. Thank you.
Anonymous here. Hello?
Ms. Leger?
I hear him.
There's a speaker before this last one that goes first.
I'd like to speak. I think that was me.
Correct. Yes, wait for Mr. Leger to let you know when the clock has been reset. Thank you.
Thank you. Can I go?
Not yet.
Okay.
I'm waiting for the gentleman who is anonymous number 4.
No, Ms. Leger, it was the person who was just speaking now. That goes before that.
The woman?
Yes.
Right. How do you want to be identified, ma'am? As anonymous?
Sure. It seems like everybody's doing that. So, yeah.
Go ahead.
Okay, thank you. I'm just confused on what is happening here. I guess the argument is that if a person is in an accident, that's an intentional act, and that becomes a use of force by a police officer. But that seems kind of illogical to me in the sense that you're saying that every time a police person is in a car accident, that they have to report that out, and it's almost like they're it seems to me that a use of force is something intentional, so that Mr. Kohrs was then intentionally running into that other person. That's pretty bad if he's saying he did that. So I guess you can reconsider, but it seems to me, I don't know why Mr. Kohrs would admit to intentionally hitting someone. Thank you.
Anonymous here.
Just a moment, sir.
Thank you.
Go ahead, sir.
In response to the last lady's comment, I don't think that's at all what Mr. Kohrs was saying, that he intentionally ran into anybody. He was talking about the interpretation of the law that the task force, or some members on the task force, had put in place. And he was discussing that. But other than that, I fully support that we reconsider. We absolutely need transparency. And I don't understand why the police commission or the respondent is so demanding and not releasing a lot of the information. I don't understand what they're trying to hide or cover. So I think we need to proceed with transparency, and everyone should absolutely read that memo that is sent on, I believe it was 6/27, as the last caller stated. That's my comment. Thank you very much.
Last call for public comment.
Sullivan. Can I speak? Sullivan.
Okay, wait for the clock to be reset.
You ready, sir?
Are you talking to me, Sullivan?
Yes.
Okay.
Go ahead.
All right. California Constitution, Article 1, Declaration of Rights, Section 3(2). A statute, court rule, or other authority, including those in effect on the effective date of this subdivision, shall be broadly construed if it furthers the people's rights of access, and narrowly construed if it limits the rights of access. top of your complaint procedures, consistent with the language and spirit of the Sunshine Ordinance, to provide the most open government possible. See City Administrative Code, Section 67.1. All inferences and evidence shall be viewed in the light most favorable to the petitioner. I strongly think that you should see all evidence in light most favorable to the petitioner. Thank you for your time.
Okay. I'm going to close public comment. We're running way over.
I've been waiting.
I heard your name come up, sir. I'll allow this last one, and then I'm closing public comment.
I'll start when you're ready.
Go ahead, sir.
Thank you. First off, I just wanted to applaud those that had doubt and were up to reconsider. I believe that there's definitely doubt within the constituents on this board, and I think that being said, I also feel that there's room to go over more of the information. I don't believe, whether it be a time constraint or not, or resources, everyone has had the time to thoroughly even understand whether there is new information within the thorough amount and detailed information that Christopher Kohrs has presented. Therefore, all these things being said, I think it would be to the benefit of the city of San Francisco that this was reconsidered, especially since the esteemed board members here, or this group of people here, there is doubt within this group. Therefore, I know, based on that there is room to look into this further, because I do respect, the intelligence of the people within this committee. So that being said, I urge that you do reconsider. Thank you very much.
Okay, public comment is closed. Members, are there any further debate or comment? Hearing none, are we ready for a vote?
Okay.
Please call the roll.
Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Forsley, absent. Member Schmidt.
Nay.
Member Schmidt, no. Member Wong.
Nay.
Member Wong, no. Member Yankee.
No.
Member Yankee, no. Member Highland.
No.
Member Highland, no. Chair Wolf.
Aye.
Chair Wolf, aye. It's 5-4 in favor.
It fails.
Yep, fails.
Okay, so I'm sorry, Mr. Kohrs, we've gone round and round on this. I would suggest your next stop possibly would be a court. The task force, I believe, has done its due diligence to provide the kind of administrative process, and that is what's required generally by court. And I don't know, there's not much else that we can do at this point. So I appreciate your time. I appreciate everybody else's time and your comments, but we must move on now with our meeting. We passed the 5 o'clock hour, and our next item is public comment.
Are we public comment?
Yes, yes.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Are you asking for public comment?
Yes, that was the item called, our next item on the agenda.
Well, yes, please.
This is general public comment.
And if you could cue anonymous number 3 after Mr. Warfield, please.
Are you ready, Mr. Warfield?
Yes.
Go ahead.
Thank you. Peter Warfield here, Executive Director, Library Users Association. Library Users 2004 at yahoo.com and PO Box 17054, San Francisco, California 94117-0544. First of all, I wanted to say that we appreciate the win, if you like, at the June 2nd meeting concerning our complaint against the Library Commission for the way that it was running its meetings in such a way that it was preventing public comment. What I'd like to ask for, and I don't think I've ever asked for this before in all the years, all the complaints that we have brought, that it be referred and taken up by one of your committees. The likely candidates are one or both of the Compliance Committee and the Education Committee. And the reason is that there were quite a number of reasons that the Library Commission's actions with regard to running the meeting violated the law. You found at least 2, and but there were a number, quite a number, that weren't specifically cited. So I think that there was a lack of real clarity as to what can be expected with respect to a properly running remote meeting. And I think that that's something that would be very worthwhile to get into and to really delineate clearly as to what's expected. I can tell you that subsequent to your meeting June 2nd and the library's attendance to defend the Library Commission, there was absolutely no change since the 2 changes that they made in March when there was a hearing imminent. They had the same incorrect and misleading instructions on the agenda, as an example. And in fact, that Thursday's meeting, there was somebody who kept swatting me down when I pressed star 3 to indicate I wanted to make public comment. So I think there's a whole question of how is it run, how is the instructions given, how is it implemented, and so on, that I think would be very worthwhile, not just for the Library Commission to ensure that they're following proper procedures, but also for everybody else and in the future. I'd also like to say I'm disappointed that Kevin Frazier's resignation is not mentioned anywhere on the agenda, and I think the chair did the right thing and notified supervisors about the resignation, but I think that should be on the agenda at the end of the where the letter, where the commentary is taken up. Thank you.
Do we have another speaker?
Yes, this is anonymous number 3, please.
Go ahead.
Thank you very much. Good evening, Task Force. This is Anonymous. I don't tell you during hearings about what impact my records requests have, because on principle, and according to the CPRA and courts which have considered the constitutional right to access public records, it doesn't matter. Every person for any or no reason has a right to public records. That's the law. That right is limited solely by statutory exemptions and sheer volume of records. It's not limited by subjective importance of those records, and importance to whom? So I'll give you some examples from my cases. You ordered disclosed an email thread of an SFPD sergeant doing forensics on a journalist's computer in an FBI task force. What you may not know is that the other portion of that thread is cited by the Reporters Committee for Freedom of the Press in a suit against the DOJ. You found the Police Commission failed to properly redact and key its emails. What I did not tell you is that those emails contained the non-Brown Act meeting conversations of commissioners discussing how to politically protect the chief of police for that raid on a journalist. You ordered production of SFPD's command staff text messages with their sender and recipient metadata, What I didn't tell you is that my follow-up to that request is what proved that Mayor Breed personally directs Chief Scott to sweep homeless people when they are within her personal proximity, and I certainly could not know, after those texts went viral and were widely reported, a new anonymous requester who discovered those texts would go on to use those tactics to find as many abuses of homeless people in city emails as possible and publish them, including on Jeff Kazitsky, who has apparently recently resigned. You haven't yet heard my complaints about Harlan Kelly's texts or the Public Utilities Commission. The contents of those texts that I found last summer via requests are cited in the federal charges against him, but I had them produced first, months before those charges. And I immediately appealed to you and to Herrera when I found out, via the native electronic files, that Kelly was hiding conversations with Walter Wong, a guilty pled city contractor. I was right in the end. Herrera and PUC were forced to disclose the remaining unlawfully withheld messages half a year after my appeal. Indeed, forcing the city to not print and scan is what allowed me to figure this out. That is the incredible power of random sampling records requests, exact electronic copies, metadata, and of appealing every single abuse of withholding, which I will continue to do. But I didn't know any of these effects would occur. They're second, third order effects, and neither did SOTF. Yet you straightforwardly enforced the letter of law in each case, which is your duty, not to judge or gatekeep the right of public access, and I hope you continue to do it. Thank you very much.
Hello.
Hello?
I would like to make public comment. Can you hear me?
Just a moment. Go ahead, sir.
Thank you very much. I have my own timer, so I don't need to be interrupted. My name is James Chapin. I made a complaint in 5 letters involving violation of 3 sections of the ordinance that are intended to guarantee that certain information is available on the internet. I sent my initial letter describing the violations on February 4th, 2020. On March 10, 2020, I sent a follow-up letter stating that I had received no acknowledgement of the receipt of my complaint and requesting such an acknowledgement. I received nothing. A year later, February 2021, my complaint was assigned to a committee hearing, and the deadline to submit a reply or additional material was February 18, 2021. A notice informing me of that fact was sent by regular mail postmarked February 19th, following day. I received that notice in due course on February 22nd. That same day, I sent an email response, which I didn't want to do, pointing out this gross negligence, which was a violation of due process and highly prejudicial to the complainant. The hearing before the Complaints and Amendments Committee was the following day, February 23rd. I sent another letter on March 10, 2021, to address the preposterous defenses offered by the respondent department. I received notice on May 17 that my attendance was required at a task force meeting on June 2nd. I sent another letter on May 27, 2021, stating that there was no authority for such a requirement and addressing additional issues with my complaint. I asked Mr. Warfield to convey to the task force that since I had received no reply to my May 27 letter, I assumed that a lack of response was an admission that there was no such requirement. At the suggestion of Mr. Warfield, I listened to the recording of the meeting and was shocked to hear Mr. Wolf state that I was challenging the task force, which he had invented out of whole cloth. On the agenda of the June 2nd meeting, I noticed that my complaint had been transformed into a records request complaint, presumably so that the respondent department could claim I had received my documents, even though no documents were at issue. This clearly constitutes a pattern and practice of defending sunshine violators against the complainants. You have to understand that these sunshine violators are involved in thousands of dollars in graft and millions of dollars in embezzlement, and concealment of those crimes is harmful to the public interest. Now, there are a lot of things you can do. I know what you're saying to yourselves. What can we do? We don't read the complaints. What can we do? Bruce Wolf is an idiot. Well, in fact, there's a lot of things you can do. You can be proactive in addressing problems of sunshine in this city.
Next speaker.
Sullivan. Anonymous.
Mr. Sullivan, are you ready?
Yeah.
Go ahead, sir.
First of all, I think the Compliance and Amendment Committee made a good motion to get input from council on my reconsideration after last hearing. Any entity or other body that is in question before the task force should be considered in relationship to the government, public officials, public money, and the entity's goal. Not doing so ignores the elephant. You should not silo the entity. Requiring a department to be named in the complaint misses the point of jurisdiction. The question of public access is not protecting one entity over another. It is about government activity through an entity for government purpose, regardless of whether they are shared with the entity. Government is to be open for all people. Changing subject. I want to point out to the task force that the mayor's proclamations and suspensions of various parts of the Sunshine Ordinance are still in effect to my knowledge. I noticed the task force is still considering findings on complaints on those suspended parts of the ordinance. In my opinion, they should be using the Brown Act or California Public Record Act, where the incidents of the complaints fall within the period of the suspension. Unless there is some memo or order I'm not aware of, there seems to be an inconsistency as to the task force implementation of public access laws that should be used and what city officials are using during this time of the declared emergency. I looked at some of the past agendas, and there are complaints that would be affected. I'm certain this will affect more complaints consideration going forward. I could say more, but I'm just going to say thank you for your time.
In the room in City Hall where I've attended many, many task force hearings over the years. There are people who are speaking that I think you have to be a clairvoyant to understand what they're saying over the telephone. It's a severe degradation of the functionality, if not legality, of these meetings. I do honor the people on the task force who are volunteering their precious time to these meetings. One of the most dangerous precedents that we're living with, and I'm very fearful will continue, is the cutting off of the telephone by the administrator who prior to December, and for at least two previous administrators, and probably even further, the administrator of the task force would answer the phone at her office phone. She stopped doing that in December and has severely inhibited, if not denied, public access to her communication with regard to the business of this task force. She has admitted in meetings of this group that she works 40 hours a week for the task force. Other records would reveal also that she gets paid $140,000 a year. I don't think we're getting our money's worth. She will not answer the telephone. She is denying the right we all have to anonymity by pretending that if you leave a message, she'll call you back. Well, that would deny my anonymity. The Sunshine Ordinance gives me the right to complain anonymously. The administrator is denying me that right. This is a violation of the Sunshine Ordinance, not to mention due process law in California and in this nation we live in. So I urge that the administrator, as I've done this in other public comments, to set aside at least 2 hours a week when she's publicly announcing that she's available to answer the telephone to communicate with complainants and the public. That has not worked since December, and I feel outraged that I'm being denied the ability to communicate with the task force and its very important business. There are other complaints I've aired with regard to the administrator, but I'm very, very concerned that when and if we ever get out of this COVID crisis, we are going to be assuming this is the new norm. It's a severe degradation, and I wish this to be stopped and reversed. Good luck. You do good work, very important work here, but a lot of it is being denied to the public because inefficiencies in the system. I thank you for your help.
Do we have further public comment?
Last call for public comment. Okay, hearing none, public comment is closed. Let's call the next item, please.
Item number 6, file number 19143, complaint filed by Anonymous against Sheriff Paul Miyamoto, James Wilson, and the Sheriff's Department for allegedly violating Administrative Code Section 6724, 25, and 27 by failing to respond to an immediate disclosure request in a timely and or complete manner. I'll read the preamble. On January 28, 2021, the Compliance and Amendments Committee determined that the task force has jurisdiction. On April 20th, 2021, the Complaint Committee moved to find that the requested records are public and referred the matter to the task force with the recommendation to combine files 19143 and 20009.
Okay. Right, so this is a regular hearing. We are going to hear from both parties first, and we'll have a period of time for discovery and questions and answers. We'll hear some rebuttals, and we'll have some deliberation to develop a motion, and so we shall begin. Ms. Leger, are you ready?
Yes, I am.
Okay, great.
5 minutes.
Is the petitioner Anonymous here?
Yes. Am I here to discuss just this one or both combined?
Well, they are not combined as
Okay.
of the moment. So we're going to be hearing them independently.
Okay.
There doesn't look like. Oh, it does. Hold on. Let me just ask. Compliance and Amendments Chair, Member LaHood, is there anything you wanted to present here? And I know there is a recommendation to combine these files.
I'm sorry. We just found jurisdiction, but I think the Complaints Committee has more to say about these.
Oh, it is Complaint Committee.
Yes.
I'm sorry. Yes. Complaint Chair Schmidt.
Well, I think that we should certainly have them in the same, consecutive, because they involve the same parties. But I don't know if there's any real reason to combine them. They do involve somewhat different requests. Both of the cases, I think the main thing I would mention is that the Sheriff's Department seems to have been sort of slow on the uptake here, but they did acknowledge at our hearing that they're trying to sort of, I don't know if you'd say make amends, but they're trying to improve their process. And so I do think they could see that there were problems in their responses here.
Okay, so let me ask, it says here that there was a recommendation from the Complaint Committee as part of your motion to refer the matter to the task force to combine these two items. Are you not saying you're saying now that that's not your recommendation?
I don't know if I recall specifically. Again, this is Member Schmidt, and I'm not sure if combined would mean that somehow they become the same case number. Though I should allow the other members of the committee to speak to these things also.
Okay. Anybody else from the committee have anything to present? Nope. No explanation on this? All right.
This is Member Wong. I am not speaking specifically to what the complaint committee found, but I was a little bit confused because it says that we, on the Compliance and Amendments Committee, found that we had jurisdiction on January 28th, but it looks like we didn't have a meeting that day. I think we had a meeting on the 26th, and I don't actually see either of these files on that agenda. Can someone maybe double check that or double check me on that?
One moment.
That would seem to be more what one would expect here. Is
Complaints and amendments met on the 28th. On the 26th. January 26th.
May the petitioner provide some information here?
One moment. Just give me a moment for a second. Yes. Go ahead, petitioner.
I believe this is one of those 45-day issues. I believe this was determined for jurisdiction maybe January 28, 2020, and not 2021. That might be the confusion, but I can't be certain. So
yeah, I think that's what happened here, and that's why compliance and amendments is noted, but that in our notes for the cases,
Okay, so
we didn't actually have a hearing on the substance of the cases.
This is Member Wong. Yeah, I'm seeing that now in the agenda for January 28, 2020.
Right, okay, I see that too. Okay. So, but the second one, 20009, was not heard at that meeting, I don't believe.
again, if the petitioner may, I can read out your motions. I have them in front of me. So
yeah, one moment. It's fine. It's just a. It's just a motion for the for finding jurisdiction, because I'm not understanding why it was heard for jurisdiction in one committee and then somehow it ended up in another committee. This was not made aware to me.
This was back in 2020. It looks like there's a typo on the agenda.
Yeah,
it says January 28, 2021. It should be January 28, 2020.
Yeah, but then it says on April 20th, 2021, the complaint committee moved to find the records that are public. So is that for the other one? 200?
No, we found jurisdiction because of the 45-day rule.
You only found jurisdiction for the first one, not for the second one.
Sorry.
Member Schmidt, 20009, did that come before your committee?
Yeah, both of these did. on the same day. And, again, it seems like they should be combined for hearing purposes. I'm fine if we wrap them together and we just hear it all at once, but I don't think that's what what we were thinking the word combined necessarily requires.
Okay, because we have a provision to allow combining of two cases if it involves the same petitioner with the same respondent, in order to, if the merits are close enough together, so that we don't have to have a duplicative hearing one right after the other. So we combine them together, and we would, if there, and the respondent can claim that there's a difference between them if we choose during the discussion about combining. Okay, because the motion to combine is public comments open to everyone, including parties, for that. So that's what this is. That's what we're trying to ascertain here.
Okay. So it sounds like you're saying that there'd have to be a motion to combine here, and okay, and that's not something I necessarily need to go into as a motion to combine. Let's just hear them one after the other.
Okay, so here's so we have an issue here. One, that item 19143 has been heard twice by committee for jurisdiction. Okay, that's the first thing I want to notate. Second thing is 20009 was heard once by the complaint committee on April 20th. Okay, and the motion on April 20th, you heard both these. You heard 19143 first, and then you heard 20009 second. And in the second one, the motion was moved by Member Stein, second by Member Forsley, to find that the task force's jurisdiction, find the requested records are public, and to refer the matter to the task force for hearing, with the recommendation to combine the files. Okay, so that's where we're at right now. Okay, so if you have any information, or any Member Stein has any information, this Member Forsley's not here, to help the rest of the task force out as to whether this should be combined or not, then let's deal with that first, so we can move this forward.
I don't think I have anything to add. This is Member Stein.
Okay. Okay. So, all right. So we have. Then let's proceed with them to be independent. I'm not hearing any compelling information to combine them at this time. I read through these. I would take them independently or combined, either way. Somebody wants to make a motion to combine them, happy to take it. Otherwise, let's proceed. Okay, let's proceed. Ms. Leger, you ready with the clock?
Yes, I am.
Okay. Is there a representative from the Sheriff's Department, or Sheriff Paul Miyamoto, or Mr. Wilson, James Wilson?
This is Allison Lambert on behalf of the Sheriff's Department.
Okay, thank you very much. Okay, Petitioner Anonymous, you have 5 minutes.
Thank you very much.
This is for file number 19143.
Thank you. Ms. Leger, please let me know when I may begin.
Yeah, go ahead.
Thank you very much. So this is only the first complaint, and it is on page P714, or page 88 of item 6. Basically, I had done my standard 10 to 20 sent me emails, 10 to 20 received emails, the department head, and a future and past 1 week of calendars of the sheriff. They responded, their IDR was untimely responded to. And the big thing here is that they basically, their response cites almost every CPRA exemption instead of reviewing the records and only citing the specific exemptions that apply. And when they cited all of those exemptions, they also cited a number of exemptions that are not allowed in San Francisco. And so I've listed them here. The CPRA requires you to, quote, provide a reason, for why records are disclosable. I don't think citing all possible exemptions is, in fact, a reason. It also doesn't constitute the written justification for withholding. They've already admitted that they untimely responded to the IDR. They've admitted the unlawful use of deliberative process privilege. They do not admit the unlawful citation to Government Code 6255, an impermissible balancing test, but it's literally right in there. They claim, as those other agencies have claimed in the past, that, well, balancing tests are sometimes allowed. Whether some other balancing test is allowed is not at issue here. They claim they were using the one under 6255, which is explicitly prohibited by the Sunshine Ordinance in 6724 G and I. And finally, they cite that all drafts are exempt. That's not true. In San Francisco, that all draft CPRA exemption is not valid, and only a very small subset of drafts can actually be exempted. And I guess in this complaint, that's all that matters. And no, I was asked this during the complaint committee. Metadata and other things aren't relevant here. We're just talking about this fact that they believed they could use all these different CPRA exemptions when they cannot. And they've admitted some of these violations and not admitted some of them in their response to you. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the petitioner or complainant? Okay, hearing none. Sheriff's Department, Ms. Lambert.
Thank you, Chair and committee members. This is regarding complaint number 19143. The Sheriff's Office has taken remedial action on how all public records requests are handled. We've implemented new practices and procedures to improve our response times and responses to all public records requests. We have learned from our errors in responding to Anonymous's public records request. And since the records request at issue came up, all 3 staff members have attended public records courses offered through the California Peace Officers Association 16-hour training class. And as of the middle of June 2021, Sheriff's Office has implemented a new public records portal. It is public records management software to help us streamline and keep better track of our responses and requests. This type of error that occurred with the response to this public records request is not going to happen again. We are making every effort to be in compliance with the San Francisco Administrative Code and California Public Records Act. Thank you.
Thank you. Any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members, questions and answers, clarifications? Vice Chair Yankee.
Thank you. First of all, I would like to say that I think this is the first time I've ever heard that a respondent has actually sent folks to additional training, and so I just wanted to recognize that. I think that's commendable, and I appreciate that. I guess just my simple question would be: are there any portions of the presentation made by Anonymous and the violations that he alleges that the Sheriff's Department does not feel are proper allegations?
I would like to respond that the letter that is sent out to acknowledge public records requests, the one that Anonymous has objections to and the allegations to, we have stopped using that letter in its entirety. Staff that is assigned to public records consults with our legal counsel before we ever cite any exemptions and looks at denial letter is sent out. So the denial letter that was originally sent in response to this request
no longer in use. Thank you.
So just to make sure I understand. So, like I said before, I really appreciate the work the sheriff's office has done here to make corrections. But at the time of this alleged violation, it sounds like you're pretty much admitting that the violations that Anonymous found at that time, you're acknowledging them?
Yes, this predates my coming to this position in the office. So okay. I can only say that it went out before I started.
Gotcha. Okay, thank you. That's all I had.
Member Stein.
Yeah, so I was actually going to ask Ms. Lambert if they still mentioned possible exemptions in their letter, but I think she spoke to that. So I guess I have a question for Anonymous, which is, have you seen a current copy of the letter, and would you concur that they're not just preemptively trying to mention all possible exemptions?
Thank you for that question. I would have to demonstrate what they did after they claimed a change in the next complaint, which is why I was asking them to be combined. But yeah. If you want me to go into that, I can, but...
Yeah, could you just answer that question?
So in the next complaint, you'll show that they didn't give any justifications. They would just give records, and there's no justifications, no keys, no nothing, so...
No, not justifications, but I mean, have you seen their revised sort of form letter that they send to people that mentions possible exemptions that they might invoke in answering a request?
No, I haven't, because I think they've changed the procedure, as they told you at committee, twice. Once after this complaint and once after the second complaint. So I haven't seen after that.
I'm just wondering, maybe for Ms. Lambert, if it's possible for us to get a copy of whatever generic letter they send now when they get a complaint. Yes, it is public record, so I certainly would be happy to provide any number of our standard response letter to the committee. Okay, thank you.
Member Schmidt.
Yes. First, I want to ask a couple questions of Anonymous just to make sure that I'm clear on the scope of what's going on here. It sounds like only 6255, specifically the deliberative process privilege, that's the only balancing type of state law that you feel is implicated in this case. Is that correct?
No, it is that is not correct.
Okay. Are they asserting other balancing tests that you contest with regards to the matters in this case?
Yes, they are. At least at the time when they responded to me, they were. So that's bullet number 3 and bullet number 4. So they said, we will not produce documents exempt from disclosure under the deliberative process privilege. That's one thing that's prohibited in San Francisco. And then they had a separate paragraph that says, no documents will be produced where the public interest served by not disclosing the record clearly outweighs the public interest by the disclosure of the record under Government Code Section 6255. And those two are explicitly banned by G, H, and I. If you're asking, I'm not in this thing, and nor were they raising about official information privilege and other types of possibly balancing tests.
Okay, so we're not in that here. I know we'll get to it at some point.
Yeah.
But we're not in that here. I just want to make it clear because at some point I think there's going to be some law that's going to have to come out on some of these state balancing issues, and there may be disagreement, etc. The second thing too for you is in the record, I noticed that at page 679, you took this to the supervisor of records, and they invoked the rule of reason. Am I correct on that?
They invoked the rule of reason? The supervisor of records did?
I believe that you got a letter,
what page is it?
679 in this record.
Oh, yeah, I see what you're saying. So this is badly threaded. That is a response on their ability to respond to a petition, not about the records at issue in this request. It's about the city attorney's response to the petition.
Okay, so, but that in itself, do you feel that their invocation of the rule of reason was in compliance with sunshine?
I don't think I can argue that in this complaint because the respondent isn't the city attorney's office. So.
Oh, I know you're not. I know you're not bringing that right now. But do you feel like there was a violation there by the supervisor of records in those circumstances by invoking the rule of reason?
How is it relevant to the sheriff?
I'm sorry, could I just get an answer from the witness, please?
I don't know. I have to decide whether I want to. I did not dispute it at the time, if that's what you're asking. I did not.
Okay.
That's in January 2020. Okay. Yeah.
If the chairman wants me to, I don't have any further questions.
If you can answer my question, how is that question regarding what the city attorney responded to relevant to the actions of the sheriff?
It's relevant because I want to know. Do I have to somehow demonstrate relevance for my questions?
Not necessarily, unless it's way off topic.
Okay, so you're asking me, like, you're pre-clearing my questions?
I'm not pre-clearing your questions. I'm asking a question now of how is that relevant? Maybe it's of interest for the rest of the task force to know.
Because I want to know if this person considered and maybe made a complaint, because the rule of reason, I think, it being invoked there is very questionable. And so I want to point that out. That's why I think it's relevant.
Okay.
So.
Yeah. But that's I don't want to get deeply into that. I just wanted to ask that one question about it, Chair.
May I clarify my response?
Please do.
I want to be clear. I did not concede that it doesn't violate the rule of reason. I said I did not file anything at the time, and I haven't considered it. So I want to be clear. I'm not conceding something in the future. Thank you.
Okay. Thank you. No more questions for me.
Okay. So I'm going to ask you, Petitioner Anonymous, on page 678, that thread of what is that all about? Why is that in the record?
I mean, I don't know why things go into the record or not. This is I need to read what this is. This is a email that's me responding to Cheryl Leger when she was sending me a response from the sheriff's department, and I just replied, and that's the remainder of the thread.
Okay, so that made that particular response is, I mean, it says here on on page 679, January 14, 2020, the subject line was complaint filed with the task force, file number 19143, which is this one, a response by San Francisco Sheriff's Department, Dear Anonymous, and then attached is the response from the Sheriff's Department to your complaint. Okay, so on January 13th, there's a response. There's a response from Bradley Rusi from the city attorney's office. Was that in particular directly particular to this case?
I don't know. I mean, I am guessing, but I don't know that he's responding to a petition about these same records that I sent to the supervisor of records. That's my assumption, but I can't be certain because it doesn't tell me who it was, when it was, like who it was sent to or anything. So it just says a subject line.
All right, thank you. Ms. Lambert, I'm sorry, what is your rank again, please?
I'm a civilian employee. I'm a legal assistant.
Oh, okay, thank you. When you were mentioning about the additional training, has Sheriff's Department done a review of whether employees have also completed the Sunshine Ordinance training?
I do not know the answer to that.
Okay, thank you. Any other questions or clarifications? Okay, are we ready for rebuttals? Okay, let's go with rebuttals. Ms. Lambert, you're first. You have 3 minutes for rebuttal. Mr. Leger will tell you when to begin.
Thank you. The Sheriff's Office wants to reiterate that we've taken remedial action and are no longer claiming blanket exemptions to any and all public records requests. Thank you.
Thank you. Petitioner Anonymous, you have 3 minutes. Wait for Ms. Leger. Thank you.
Yes.
Thank you very much. They are correct that they claim that they are now no longer doing any of these things, even though I think in their original response they were only willing to admit some of them. So it's great. That's good to hear. I don't know that myself personally. I think one of your members asked them to give you that letter, and that's great that if maybe, I assume that kind of thing would happen at compliance if you agree with me that there was a violation here. I would simply ask that you find the violations on page P714, which is page 88 of the PDF. Citation to written justifications that do not apply to the responsive records, untimely immediate disclosure request response, unlawful use of deliberative process privilege, unlawful citation to Government Code 6255, and impermissible balancing test, and unlawful citation to CPRA draft exemption. If there's any confusion on that last one, they are able to cite the far narrower version of the Sunshine Ordinance's draft exemption, just not the fact that all the preliminary drafts and memoranda are exempt. And that is, and please do send it to compliance so you can review what they're doing now. Thank you very much. I'm done. I don't know if you guys can hear me, but thank you.
Okay, thank you. Okay, members. Any further discussion or motion? Members, then.
Yeah, so, my understanding is Anonymous is asking for a violation of 67.25, 67.27, and 67.24. I just want to say I'm more reluctant on this idea of a violation of 67.24, which talks about the kinds of public information that must be disclosed. Because although I don't think the Sheriff's Office was correct about the exemptions they were saying might apply to a request, I think it is kind of, it's not great practice because it might turn off some petitioners, but I think what they were saying in that letter is that these are exemptions that might apply. They weren't citing them as exemptions that they were using or utilizing in any, in this particular case or any particular case, right? So it wasn't that they withheld the information for these reasons. They just said these are reasons that might apply, and they were incorrect, but I'm not sure that that's a violation of 67.24 because they didn't actually use those exemptions. That's just all I want to say.
You're basically refuting that they admitted it by mistake?
I'm saying they wrote a form letter that said, oh, we've seen your request, and in replying, we might take this slew of exemptions into account. They were incorrect about what some of the exemptions were, but they didn't take them into account.
Yeah, but was that in response to the request?
My understanding is that
Hold on.
that they list out all these exemptions that they say in like one of the later paragraphs may apply. They don't say like these are exemptions we are applying.
My question is are you stating that was what they said to the requester, or was that what they are telling the task force as their defense?
I'm just saying that I'm not seeing necessarily a violation of 67.24. They said this to all the requesters. They sent out a form letter. They said these exemptions might apply. These are potential exemptions, but they don't say that we are using these exemptions in any, in that requester's case or anybody else's case.
But my question is are they using that as a defense here before the task force? Are they saying to us they didn't provide, they weren't providing these records because of that?
I don't think they are.
Okay, because that's what what they tell the requester is one thing. What they tell the task force is their actual reason for not disclosing the records. Now, if they tell us that at the time before, the agenda is being created and they're requested to provide their response, and it's in there, then we can determine whether that was correct or not. They could say whatever they want to the requester, and whether that's correct or not is part of the complaint. So I'm trying to discern.
I don't know how I can be more clear, but my understanding of this case is that Anonymous wants us to find a violation of 67.24, which talks about the different kinds of information that must be disclosed, because in that form letter, they suggest that they would hold those exemptions, or they would utilize those exemptions in some cases.
Okay. I guess what the big concern I have here that's missing from this hearing is that we're not hearing from the sheriff's representative what exactly their defense is. So if you look on page 773.
No, but to me that would be about not offering justifications for withholding. That's 67.27.
Okay. I'm going to make a tertiary comment here.
Okay, sorry.
The comment is if we did not hear from Ms. Lambert, the representative from the sheriff, what the response is from the sheriff's department as far as what their defense is, or either they are pleading no contest, or are they citing certain sections of the code in defense of not providing the information properly that the complaint is about, so on and so on. So what I'm saying is that if you go to page 773, that is their response to the task force. Essentially, should have been, actually, Ms. Lambert's signed it there. So this was her writing. So they're citing that the requester was provided all relevant response records according to their request just 2 days later. So they're saying that they did not violate 6725. I don't necessarily have to or want to make their case for them. Okay, but it's all listed here. The question is whether you're refuting any of those citations, which it sounds like you are, for 6724 Was there a particular?
Sorry, I'm looking for page 773.
It's printed on the PDF at 773 at the bottom. It's PDF page 147 out of 242.
Yeah, I'll have to look on that. You can go on. I just
okay.
That point.
Okay. So, Member Schmidt, go ahead.
Yeah, I would say that we are looking at a 6255 citation and a deliberative process privilege citation, and there seem to be violations in citing those. I think if we make it clear that we're finding violations of those two, then that's maybe what would belong in a 67.24 violation. And maybe also adding in unlawful citation to the draft exemption. That I'm not sure if that belongs or not. But I don't know if we have to get into 1040 and all these other things that really are not part of this, as far as I can tell.
Would enjoy a motion. Go ahead, Member Schmidt. Raise your hand.
Yeah.
Okay.
Okay, I'll be happy to make a motion, which is pretty much down the line of what's requested, although I'm going to make some small edits. 6727 citation to, I'll just say written justifications that do not apply. 6725 untimely IDR response, and then 67.24 violation involving the deliberative process privilege, citation to government code 6255, and to the draft exemption in the CPRA. So those are the violations that I see, and that's my motion.
Okay. So,
Can I get some clarification on that? You are moving to find a violation of 6727 for written justifications that do not apply, 6725 for an untimely response, and 6724 for the deliberative process. Is that correct?
Yeah, deliberative process privilege citation. Citation to 6255 government code. And also citation to the CPRA draft exemption. Improper citation.
is there a second?
This is Member Neighbors. One second.
Moved by Member Schmidt, second by Member Neighbors. This is to find a violation of 6727, that written justification does not apply. 6724, deliberate process was incorrectly applied. That's the 6725 untimeliness. Okay. Any further debate or discussion on the motion to find violations of these three sections? Okay, let's go to public comment. Is there any public comment on the motion? Public comment on the motion. Okay, last call for public comment. Okay, public comment is closed. Any further comments, discussion, members? Are we ready for a vote? Okay, please call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
Aye.
Excuse me. Member Padmanabhan, aye. Member Stein?
Aye.
Member Forsley, absent. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find for 6727 of written justifications that do not apply, 6725 for an untimely response, 6724 for the deliberative process incorrectly applied, and Government Code 6255 improper draft of exemptions. Second by Member Neighbors.
Thank you. Please call next item.
Item number 7, file number 20009, complaint filed by Anonymous against Sheriff Paul Miyamoto, Lieutenant Quantico, and the Sheriff's Department for allegedly violating Administrative Code Section 6726 and 27 by failing to justify withholding and keeping withholding to a minimum. It is the same preamble as the previous case.
Okay. Let's hear from the, first of all, Member Schmidt, is there anything you want to present on behalf of the complaint committee?
Just quickly that I think this one is also the sheriff has the Sheriff's Department has acknowledged that they're making changes, which I certainly commend. And so I think there's also going to be, you'll see that there's some acknowledgement that they didn't properly redact and then give citations for the redactions on a lot of these documents. I think that's pretty much it. Anything else, Member Stein? You're here. Anything else that you recall?
No, I don't have anything to add.
Okay, thank you. We'll hear from the parties next. I imagine both parties are still here. We'll start with Petitioner Anonymous. Mr. Leger, please wait for Mr. Leger. And
Anonymous, ready to speak?
you'll have 5 minutes.
Yes, I am.
Go ahead.
Thank you very much. If you still have the previous case open, I'm not sure why, but I put these in both files. It doesn't seem like the presentation for this one is showing up in item 7, but it is in item 6, page 89. Even if you can't see it, this is a very simple complaint. Once I realized what they were doing with these cover letters to me, I actually requested all of their records request responses to all other people for about 1 year back, and to see how extensive this was, who else was getting this. And I believe every single requester had been getting this for at least the past year. And when they gave me those records, which are the records about their responses to other people, they didn't key their redactions, they didn't justify at all why they were withholding information, and as I believe they also acknowledge, they had withheld the names of the records requesters, which is not exempt. I do have a supervisor of records response, and I don't know if it's actually in here, not against the sheriff, but against SFPD, where they say that records requesters' names are not private and should be disclosed. That was not a ruling against the sheriff. I'm just telling you because that's a ruling that the supervisor of records has made, and I think they accept it. So it's pretty simple. They had stopped by this time using those blanket exemption letters at this point, and but instead now the new problem was they weren't giving any justifications or any redaction keys, which is, I think they're going to tell you they revised their procedure again after this complaint. So the three violations I would ask you for are 6726 for failure to provide a key or other clear reference from redactions to justifications, 6727 for failure to provide written justification for withholding, and 6726 for non-minimal withholding for redacting the names of records requesters. I don't believe there's actually on this one anything in dispute unless they're claiming still some of those names are exempt. And they made some sort of argument like that possibly at the committee, where if it's a prisoner, there's some extra exemption applies, but I'm sure they'll explain to you if they're still, I don't know if they're still arguing that exemption for prisoners who make records requests. Thank you. That's all. Thank you.
Okay, thank you. Are any persons or witnesses providing facts or evidence on behalf of the petitioner? Plaintiffs. Hearing none, I imagine the same representative, Ms. Lambert. You have 5 minutes.
Yes. Yes,
Please
thank you.
Please wait for Ms. Leger.
Go ahead. Thank you. This is Allison Lambert on behalf of the Sheriff's Office regarding complaint number 2009. We reiterate that the Sheriff's Office has taken remedial steps on how all public records requests are handled. The history behind this request is that it was received on a Saturday. Seeing that it was an immediate disclosure request, we went ahead and tried to respond as quickly as possible and later offered to send justifications, feed redactions to the requester. Having not heard from the requester, we went ahead and sent an updated production on February the 20th with all of the redactions justified and keyed for the reasons why. In terms of a prisoner making a public records request, we do not release any identifying information on a prisoner that is a criminal history that's exempt from disclosure. And as with the previous complaint, we want to reiterate that this came in while our unit was in the process of receiving training in how to handle these, all of our public records requests. And we're making every effort to comply with the Sunshine Ordinance and government codes. Thank you.
Okay, I'll assume that's at the end of her testimony. Are any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, here, none. Members, the item is with you. Let's see. I have a question for the petitioner, Anonymous.
Yes.
With regards to the redactions, as we just heard in testimony from the respondent, they said that perhaps some of those redactions were in fact prisoners. Was there any information relating to that that you received from the respondent?
No, so they're not telling you the difference between their two responses. They responded to me, responded to my request, redacting all, without any justification, without any keys, all names of records requesters. Then I filed a complaint, and then they went back after that complaint and did this other process of only redacting prisoners' names. And it does sound like they are still holding those exempt under CLETS.
Okay, so I'm not sure what your complaint is focusing on. Is it focusing on what they provided you first and then corrected, or what they corrected later?
As always, it is my complaint is written as it was when whatever I knew at the time, which was all the names were redacted at the time, which is why I asked for that in 6726.
Yeah, but didn't they make the correction later by making the redactions?
Correct. They have now. They're now saying only prisoners are exempt, and that's their argument now. So they've gone back and taken away the redactions on every name that is not a prisoner. I believe their argument is. I don't think that the prisoner name is exempt under CLETS if just someone happens to be a prisoner when you send a records request.
And when did you receive those corrections?
After I filed my complaint.
After you filed your complaint.
That's correct. Yeah.
Okay, that was what I was getting at
yep.
here. Okay. All right. Are you talking about the responses from the Office of the Sheriff, starting on page? It looks like 33 out of 242.
Let me get to that page. Sorry, the PDF number is what?
The PDF printed on the page is 659. The page, the actual page is 33 out of 242.
Yes, that's correct. And yeah, that's their initial. That was their response to me before I filed the complaint. They just redacted all of the names everywhere with no justification or keys. Correct.
Got it. Okay. And Ms. Lambert, are you aware of the requirement?
Yes, we are aware of the requirement that the Sunshine Ordinance requires that there are justifications or footnotes for anything that is redacted.
Okay. Thank you. Member Schmidt, go ahead.
Yeah, just specifically on the CLETS issue. Question for Anonymous. Do you want to assert here that there was a violation by withholding that information under the CLETS exemption or objection?
So, again, I don't know what your rules require. I originally said it's just about all the names being redacted. That's all I knew at the time of my complaint. If you're asking me now that I know they only want to withhold the CLETS names, yes, I would still argue that I don't think that if I'm a prisoner and I send a letter to someone, my name, just the existence of me being a prisoner, is CLETS information. I believe the CLETS exemption specifically exempts information derived from a specific law enforcement database that is shared amongst various agencies. And I don't think just because someone's a prisoner, that means it was derived from that database. Thank you.
Okay. Yeah, I think that I'm with you on that argument. I wanted to figure out if that's what you wanted as part of our order. Ms. Lambert, would you have any substantive response on that legal issue as to why CLETS is a valid exemption basis in this case?
At the Sheriff's Office, we can only confirm if somebody, an inmate's records, if they are currently in our custody. So any time that we release any kind of information about anybody who was formerly in our custody, we consider that criminal history information, and we are not able to release that. Once they leave the sheriff's custody, we cannot release any more information about their identities because it's criminal history.
Okay, and so you're saying that it applies to some of the deletions.
There was actually just, I'm sorry to speak over you, there was actually just one PRA from an inmate. So we're talking about one record.
Okay, just one in the batch here. Okay, thank you. Thank you. Appreciate that.
Member Schmidt, can you or Petitioner Anonymous or Respondent Ms. Lambert explain what, and for our own edification, what the CLETS provision is?
Who would you like to answer that?
Well, whoever, if you're all talking about it. And for the edification and education of the rest of the task force and the public, I think it's worthwhile to mention to describe what that is, because we have no reference of it.
I'm happy to if no one else wants to. So.
Well, I would defer for now because it seems like, I guess it's an issue here. I was trying to figure out if it is an issue, and it sounds like it is. So let's allow the parties anonymous.
Okay, go ahead.
Sure. So CLETS, I apologize for speaking over you. CLETS stands for California Law Enforcement Telecommunications System. There's a special exemption, I believe it's in the penal code, that allows you to not provide any information from that database or derived from that database. And I don't see how that applies to the fact that a prisoner happened to make the request. The actual part of the response that may be that person's criminal history or law enforcement database derived information, I'm not contesting that. Just their name. You don't have to give me their prisoner number. You don't have to give me anything else, which prison they're in, just the name. That's all. Thank you.
And Ms. Lambert, can you expand on why you applied that and how it's applicable to this request?
Yes, our policy with the Sheriff's Office is we will not release any information on any individuals who are no longer in Sheriff's custody. So once somebody leaves the Sheriff's custody, we cannot identify if, they were ever in prison. It was considered criminal history, and that is why we will not release it.
So you're saying that if a prisoner were to make a PRA request while they're incarcerated, that is exempt. Their identity is exempt.
No, if they are still in Sheriff's custody, then their identity would not be exempt. So it does change. So say the request came from a former prisoner, we would not release that former prisoner's identity because it is criminal history information.
Oh, I see. Okay. How would anyone know that they were a prisoner?
I'm sorry?
How would anyone know from the information on the PRA that they were a prisoner?
In this particular instance, there actually was an inmate number following the individual's request.
Okay, and so if you redacted that and not their name and put a keyed the citation correctly, would that not be sufficient?
I don't believe so.
Okay, thank you. Okay, any other questions? Okay, should we move to rebuttals? Okay, let's move to rebuttals. Ms. Lambert, respondent, you are first. 3 minutes. Wait for Ms. Leger.
Are you ready, ma'am?
Yes, I am.
Go ahead.
Thank you, committee. The Sheriff's Office offered to provide updated redactions and justifications to the requester, and upon not hearing from the requester, we went ahead and did this anyway in conjunction with updating our procedures for handling public records requests. Thank you.
So when you're finished with your testimony, petitioner, you have 3 minutes. Wait for Ms. Leger.
You ready, sir?
Yes, I am.
Go ahead.
Thank you very much. I want to clarify again because I don't know why they're not making this clear to you. That was only after I filed a complaint that they offered to do this, and then they did it. The point, as I've made in now I don't know how many complaints, and this task force has discussed, you have to follow the Sunshine Ordinance, not because some magic words are issued, not because Anonymous knows how to file complaints, but for everyone, for each request. And when you respond and you redact something, you have to key that redaction. I don't get special privileges because I know how to file Sunshine complaints. The point is everyone gets this for every request, every time. and not because it's optional. In fact, I even discussed at your education and training committee, there's even training from a city lawyer that says the rule automatically applies. There's no invocation of the Sunshine Ordinance. Anyway, so 6726 for not not keying the redaction, 6727 for just not providing any written justification at all, but 6726 for non-minimal withholding of the names, which they admit because they changed it. And then the only real question, I think, is I would say that what the chair and member Schmidt has said is correct. This information, you don't need to give me the criminal law enforcement information. You don't need to give me any history. But if I'm just a random person who used to be a prisoner in the jail, and now I make a records request, why my name would somehow be magically exempt doesn't make a lot of sense. I don't see how that has anything to do with criminal history. I'm not asking you to give me that person's criminal history. Just redact whatever you think is criminal history, prisoner numbers, whatever it is, and just give me the person's name. But even if you don't agree with me on the fact that that is not a valid CLETS exemption, you should agree with me that all the other names should have been provided initially as well, as it would appear that the supervisor of records agreed in the case with SFPD. Thank you very much.
Okay, so the item is now back with us for debate and a motion. Member Schmidt, you have your hand up.
Yeah, just that I think I would back up the anonymous side on that CLETS issue, and I think it may be a good idea that we note it in an order if we do have an order on this, because it just doesn't seem like these letters and the names on the letters would be covered by that exemption.
Okay, thank you. Anybody else? Is there a motion? Is there a motion? Member Stein. You're muted, Member Stein. Member Stein, you're muted.
Okay, how is it now?
Yes, we can hear you.
Okay, sorry. So I will make a motion to find a violation of 67.26 and 67.27 for failing to justify withholding and keeping withholding to a minimum.
This is Member Wong. I'll second that motion.
Okay, moved by Member Stein, second by Member Wong. Find violations 6726 and 6727. Can you give a little just narrative as to what actions you're finding the violations for each of these? We've been requested by many members of the public in the ODs that they're not descriptive enough.
The information was, I'm there, right? The information was redacted with no explanation or improperly redacted with no redaction keys, that the names of requesters were withheld.
And for 6727, the same thing, no justification for withholding?
Yeah, no, that was to cover both of them.
Okay, got it. Okay. I would just ask, is there a timeliness issue here? So it seems on, I think what I'm looking at here on, let's see.
It was filed on December 7th and it was received on December 18th, right? It was an IDR.
Right. I think that's the right one. Everything's over here. It's hard to separate which one's which from these. Let me just get clarification from the petitioner. Can you point us to the page for 20009, this case, this file number, with regards to the when you filed the request and the chronology thereafter?
I can tell you there is no timeliness violation, and you can see it, and I haven't asked you for one. It's on P875. I made the request on January 11th. They responded January 14th, but there was a weekend in between, so there's no timeliness issue.
Okay, great. Thank you. It's just because the other file is also all together with this, so it's hard to tell. Okay, very good. Okay, any last thoughts, members? Okay, let's open up for public comment. Ms. Leger, hand it to you.
Second. Do we have any public commenters?
Yes, please.
Are you ready, Mr. Warfield?
Yes, let me know when to start.
Go ahead.
Thank you. Peter Warfield, Library Users Association, Library Users 2004 at yahoo.com and PO Box 170544, San Francisco, California 94117-0544. We're not a party to this complaint. We're not particularly familiar, except for what we have heard. So first of all, I'd like to say that certainly there appears to be support in the facts, and so we support the motion. I wanted to say additionally that I wish it were pointed out explicitly, and I don't know if you think it has been sufficiently, but discussing changes to procedures, particularly procedures that haven't been questioned in any way, is not a defense for what happened. You know, if you get a speeding ticket, it doesn't suffice to say you should not have the requirement to pay because you're promising not to do it again. And I could be more dramatic, but I won't. I'll just leave it at that. It seems to me really a diversion and an evasion of accepting forthrightly the responsibility that what you did was not lawful and that's the reason you're changing. We've already heard now 2 changes, and so there's a real question as to whether they are doing adequate changes. And that's why I would support what the petitioner has said, Anonymous has said, which is that it would appropriately be referred to a committee such as the Compliance and Amendments to see whether there is a continuing violation or whether they have adequately dealt with the issues of illegality that you are raising. I don't understand why a prisoner is not a public record. It seems to me that arrest records are public. I don't understand at all where a prisoner, even if it was known that it was a prisoner, would be in any way protected under any particular law. I guess I haven't heard it stated.
30 seconds.
And I also thought, I was kind of alarmed when we heard that there was training being given by some police officers association at the state level. And I think Chair Wolf rightly questioned that, but I would be more particularly saying it clearly omits the key thing here, which is the Sunshine Ordinance, which has different and more stringent rules. That's what needs to be trained. Thank you.
Any other public comment?
Last call for public comment. Okay, hearing none, public comment is closed. Members, are we ready for a vote? Okay, please call the roll.
Member Stein?
Aye.
Aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley? Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Stein, second by Member Wong, to find a violation of 6726 for failing to justify withholding and 6727 for failing to provide proper redaction.
Okay, thank you. The order of termination is approved. I would request that we take a 10-minute recess, and we will return. It's 7:09, so let's see. So it's 7:29. So let's make it 7:30. Okay?
Yeah, okay.
Okay.
2 minutes.
You realize that's 20 minutes.
I'm sorry, I made a mistake.
I think you mean
7:20.
Okay.
7:20. Okay, thank you for the correction. Okay, we are in recess until 7:20. Thank you. Can you please call the roll? Ms. Leger? Ms. Leger? Ms. Leger?
It's odd. She was just here a couple of minutes before you all showed up. So.
Ms. Leger? Victor, are you there?
Yes, I am. I'm calling to try to let her know that we're ready to start. Give me a moment.
Thank you.
I'm trying to contact her right now.
I appreciate it. Thank you.
Bruce, Chris here. You said 7:30.
Sorry?
You said 7:30.
No, we corrected it as 7:20 because it was 10 minutes. It was 7:09.
Yeah, I don't know if people heard that correction. I didn't, so just saying.
All right. Well, thanks for being here.
Well, Chair Wolf, I can go ahead and get us started.
Okay, great. Thank you.
Give me a moment. I wasn't keeping track of the rules, so please forgive me.
I want you to call the roll.
To reconvene into open session.
Yeah.
Member Schmidt. Present. Schmidt present. Member LaHood.
Present.
LaHood present. Member Devon. My apologies.
Present.
Present. Member Wong.
Present.
Wong present. Member Stein.
Present.
Stein present. Member Yankee.
Present.
Yankee present. Member Highland.
Present.
Highland present. Member Neighbors.
Present.
Neighbors present. Member Forsley. Forsley not present. Chair Wolf.
Present.
Wolf present. We have a quorum. I believe we were on item number
number 8.
Item number 8. Item number 8 is complaint filed by John Hooper against the Office of Economic and Workforce Development for allegedly violating Administrative Code Section 67.21 by failing to respond to a public records request in a timely and or complete manner.
Apologies, group. I just stepped back in.
Okay.
Yes, Administrator Lejar, we just took roll call, and I just called item number 8. We have not called any members to speak yet. I will turn it back over to you.
All right, thank you.
Ms. Leger, if you can read the byline for item number 8, please.
On December 2nd, 2020, the task force requested that the petitioner provide a bullet point list of missing documents to the Office of Economic and Workforce Development, and that the matter be referred back to the complaint committee once the records have been identified and exchanged. On February 16th, the complaint committee continued the matter of the call and share with a request to Mr. Hooper to provide details or documents or not documents that were provided based on the 21 bullet points.
Okay. Complaint Committee Chair Schmidt.
Yeah, I'm not sure if I was the chair at the time. Maybe I was, maybe I wasn't, but I'll try to report what I recall. Yeah, we definitely, with this first case, which is against the OEWD, as you can see, it's quite a lot of documentation here, and this thing's been going for quite a long time. But Mr. Hooper's been just kind of fighting to get records, and it appears that finally he's still getting some new records, even as of May or June. And those are the records he's been looking for a couple of years. And it involves it involves records from, he wants records from a private entity, Parks Alliance, and that's a major issue in the case as to, how he can or should go about getting records that will be held by Parks Alliance. I'll leave it at that. Any other members of the committee at that time who want to say anything, please do.
I just want to note for the record that the members of the committee at that time was, Member Hinsey was the chair of the complaint committee, you yourself, and Vice Chair Yankee. Vice Chair Yankee, do you have anything to add?
I don't believe so. I think that there was still some dispute about whether some records existed related to, contracts and so forth. And and I believe we felt that, OEWD, needed to look a little harder, that Mr. Hooper needed to zero in on what exactly he felt was still outstanding. And so my understanding is probably now we're at that point where we can take a look at that.
Okay. And on that particular day, I actually stepped in for Member Hinsey for that particular meeting. And I recall the same as far as that's concerned. Okay, so let's begin. Mr. Hooper, are you here?
Yes, Mr. Chairman, can you hear me?
Yes, I can hear you perfectly.
Okay, great, thank you.
Great. And
Mr. Chairman, members.
Hold on a minute, hold on. I just want to ask if the respondent is present.
Yes, I'm present.
And who is speaking?
Mary Yamazuko Thompson from the Office of Economic and Workforce Development.
Okay, Ms. Thompson, thank you very much. Okay, Mr. Hooper, you'll have 5 minutes for your opening testimony. Please wait for Ms. Leger and the clock. Thank you.
Mr. Hooper, are you ready?
I'm ready.
Go ahead, sir.
Mr. Chairman, members of the task force, thank you for this opportunity to carry on this discussion I realized, going over my notes since the December 2nd meeting that was referred to, that this will be my 9th time speaking to you, either on the agenda or in the form of public comment. So I do have a couple of new things to add, but by and large, I think one of the main points I'd like to focus on, because it appears to have been something that has been confusing for the task force, is in this situation where the city is running and financing programs involving more than one department. Who does one ultimately expect to disclose documents that have been referred to? And as you may recall, at your December 2nd meeting, you decided this was a multi-agency effort involving both OEWD and the Department of Public Works, and it was appropriate to keep the complaint separate. And what that really means is that you understood that the responsibility remained with both of the agencies to disclose the public records involved. Now, it got complicated after that, and you may recall that at a Complaints Committee meeting on March 5th, the Complaints Committee essentially contradicted that former decision and I guess you'd say released Public Works from further responsibility to provide documents. So since that time, you know, having been told repeatedly there's nothing more, and you may have it, I submitted the reference last week in my written comments, but Deputy Attorney Hank Eckel submitted something like 1,740 pages of information within the last month or two. And within that, there's a lot of stuff that we've all seen before, but within that, there were a couple of pieces of information that I wanted to make sure, and certainly hope you don't have to read 1,741 pages, but that you be aware of. On the 2nd of January 2018, responding to a question from Beverly Ng of the Recreation Park Department, Chris Kohrs of OEWD wrote to her, GWD is run by the Department of Public Works. GBD, Green Benefit Districts, which is what this is all about, is run by the Department of Public Works. Later, can you hear me? I'm getting a lot of static.
Yes, I know. Miss, can you please stop the clock, please? Member Stein, can you please mute your, wherever you're doing is running over your microphone? Thank you. Okay, please restart the clock for Mr. Hooper. Thank you. Sorry for the interruption.
Not at all, Mr. Chairman. Do you want me to continue? Were you able to understand what I was saying before?
Yes, I think we've got where you just got up to right now, that the GBD is, you're claiming the GBD is part parcel to OEWD. Please proceed.
What? I'm not claiming it. I'm quoting an employee of OEWD state clarifying that for a member of the Recreation Park Department staff. The GBD program is run by the Department of Public Works. That has been a source of past, which is why I want to put some attention to it now. Another quote that emerged from the Hank Henkel info. Also a quote from OEWD's Chris Kohrs in a communication with Ray Rivera, who did for Parks and Science, is merely a conduit for a grant to get through. Jonathan Goldberg being the
all right, we're losing you, Mr. Hooper. We're losing you, Mr. Hooper. We can't hear you now.
Can you hear me now? Can you hear me?
Yes, I can hear you now. Please repeat.
Oh, sure. Mr. Chairman and members of the task force, just parenthetically, I live in the Haight-Ashbury part of San Francisco, and we have had no power since 8 o'clock this morning. So I'm running kind of on the low side off a battery on my cell phone, no access to my computer and so forth. Okay. So if I disappear entirely, PG&E said they'd have it all back on, at the close of ordinary business, but we still don't have power out here.
All right, let me ask you, Mr. Hooper, if we do lose you in the middle of this, would you like for us to continue the item?
I can't imagine anyone would. I think the Ripper, God bless us all. I believe if we have technological difficulties, that the materials that I've provided you, even just going back to the 2nd of December of 2020, should give you more than adequate information to base a decision that I have yet to receive what I've asked for. So I would hope, even if I get, if I disappear into the ether because of low battery, that you would feel free to continue. And I also believe there may be a member or more of the public who is very concerned about this issue, and they might be able to chime in if I suddenly disappear off the radar. But anyway, I hope so. Anyway, Mr. Chairman, the reason I emphasize that issue is that was the principle.
All right, give him another 30 seconds for the input that I made.
Yes, just to clarify, members of the task force, that was really the main point of confusion that you were all struggling with. Should the responsibility be placed only on OEWD or both OEWD and DPW? I contended, for reasons that I won't bore you with and you can read in the next 10 minutes, that it's a joint venture, so to speak, a multi-agency effort, and both agencies are equally responsible for providing the information. So that's really all I have to say, and I appreciate the time.
Thank you. Are there any persons or witnesses providing facts or evidence on behalf of the petitioner, the complainant?
Sullivan.
Okay. Thank you, Ms. Sullivan. Go ahead. You have...
Well, I just want to start off with saying that we did a number of public record requests, and Mr. Eckel gave us documents that were new that he should have received within the date of his request. I don't know if they've been submitted or not to the task force. I do want to talk about city contracts have a number of clauses stating city ownership of all documents and work product. The city expects to receive the work it pays for. Records produced by city contract are city records, and they are therefore public records. City Administrative Code 2134, Audit of Contract Records, allows for the city to inspect records related to the performance of all contracts. Quote, such books and records shall be maintained by the contractors for 3 years from the date of the final payment under the contract, unless a shorter period is otherwise authorized in writing, end quote. This is echoed in city contracts. Failure by contractors to retain records is failure of Sunshine Ordinance 6729-1. Originals of these documents shall be maintained consistent with the retention policies of the city and county of San Francisco. In this case, the retention policies for the contractor is mentioned in the previous code, 2134, that I cited, and in all city standard city contracts. The city, OEWD, has the right to get city records. The contractor, SFR, Alliance, or TGS must retain those records. Reason for these clauses are for accountability of contractor spending the city's public money. Public record and access laws are for public ability to hold public officials accountable, and those acting on behalf of the government. Those acting on behalf of the government are doing democracy, and with few exceptions, this right exceeds any other policy interest of government officials, and I'm adding those acting on the government's behalf may use to prevent public access to information. Sunshine, Section 67.1B, and I thank you for your time.
Are there any other persons or witnesses providing facts or evidence on behalf of the petitioner or the complainant? Okay, hearing none. Respondent, Ms. Thompson, you have 5 minutes. Please wait for Ms. Leger.
Ms. Thompson, you ready?
I'm ready.
Go ahead.
Okay, thank you. So I just want to clarify a few things. First of all, in the February meeting, the task force asked us to support Mr. Hooper by matching our responses, the 1,700-page documents that we had sent Mr. Hooper in his original request. You asked us to support him by matching our response to his original request. I also want to clarify that Mr. Heckel was responding on my behalf as I was deployed to the COVID Command Center. So I need to clarify that the response that Mr. Heckel gave Mr. Hooper, Anonymous, and Mr. Sullivan were the original 1,700 documents that I gave Mr. Hooper. So on May 3rd, Hank gave Mr. Hooper, Anonymous, and Mr. Sullivan an index of 21 category of records for the Green Benefits District. We did this at your request, and we responded to all 21 requests and all 21 questions. What's noted is we don't have documents for 5 of the items, potentially even more of the 21 questions that Mr. Hooper provided us with, and we have told him that we don't have those documents. And just also to clarify, Mr. Hooper, in his original response, was given all 1,700 documents. Post that, when we went back after the February meeting, we found additional documents that came in after Mr. Hooper's original request. We provided Mr. Hooper, Anonymous, and Mr. Sullivan with all of those documents. And to remind everyone, the documents we provided him did not exist at the time of his original request. While doing his request and indexing, we discovered that there were a few documents that we did not provide to Mr. Hooper in the original request. This wasn't an oversight. It was probably and potentially more of a function of Microsoft Outlook, which search capabilities changed from 2019 to 2021. We never intentionally withheld any documents from Mr. Hooper. Since the February meeting, we provided him with all of the documents. We've indexed them to respond to his 21 questions as they were presented to you and to us, and we have given him everything that he has required. And that's my response.
Okay, thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Okay, hearing none. Members, the item is with you. Vice Chair Yankee.
Sure. Mr. Hooper, I'll ask you first. It sounds like after the February complaint committee hearing that we had, that there were additional records that were turned over that you had not previously received. Can you elaborate on how many additional records you received after that complaint committee hearing that you had not received from OEWD prior? Looks like perhaps this happened, I'm guessing, looks like somewhere in April or so, from what I could tell from the attachments that I've read through.
The new information, well, not new information, some of it I've seen before on several occasions, but the latest disclosures that I've seen and that Ms. Thompson were the ones that came, the 1,700 pages came from Henkel, and that's where the quotes that I gave you a few minutes ago from the OEWD representative clarified that the Green Benefit District program is run by the Department of Public Works and so forth. So I'm trying to be responsive to your question.
Let me ask it more succinctly. Could you just give me an approximate number of, let's say, pages that you received from Mr. Heckel that you had not previously received, that was not part of the initial group of documents that OEWD had given you? Like, was it 50 more pages that were new to you that you had never seen before, or 100 more?
I understand what you're asking. I've highlighted the pages that I got from the Heckel disclosure packet, and let me just quickly. Well, I would say there, by page numbers, there's probably something like 60 documents that I had not seen from prior disclosures from either DPW or OEWD. So if that's approximate. I was just going through my highlighting of pages that were new to me from the Heckel disclosure packet.
Okay. So that's fairly significant. So with those additional documents now being turned over, do you still believe that there are even more documents that are still outstanding that you've not received, or do you believe that those additional ones from Mr. Heckel now fulfills the remaining documents that you thought may have been out there? Well, clearly were out there.
Well, the short answer is I still do not have all the information which I need to understand how the city has spent this money, and which I believe must exist because the payments were required under contract. I will say, though, that the gap has narrowed. I do understand more fully than I ever have previously the city's budgets for these several green benefit program publicly financed campaigns that were run. I now have seen, and I consider it new information from the recent Hank Heckel disclosure, several requests for payment from Parks Alliance or its predecessors, Build Public or Place Lab, which I don't believe I've seen before. But what I still can't figure out, so the budget seems clearer, certain requests for reimbursement from the contract agency, Parks Alliance, are now there, but I don't see any records of city payments. So what I'd like to be able to say, when I talk to my supervisor or the mayor, is why has the city spent whatever it is, $1 million on public campaigns to voice programs upon an unwilling public instead of providing basic public services? That's what this is all about. So this is a long answer to say, no, I still cannot figure this out, and I still believe that the data I require is very simply right. It's required by contract. So, now the complicating thing, in fairness to everybody, is that these efforts funded by DPW and OEWD and staffed by them failed. So it's not clear that all the money that may have been budgeted actually got paid out. And
Mr. Hooper?
But yes, please.
Yeah, so to follow up, is there a way that you could very succinctly describe, what you believe is still outstanding? Like, is it
yes,
payments from the city? Is it a contract? Just very succinctly describe what you think is still you have yet to receive.
I can reply to that very simply. The information which I have not received is the records of payment from the city. I have requests for payment, in other words, invoicing, but I do not know what the city paid in full or in part, depending on how far these failed efforts actually got.
Gotcha.
So it's a simple answer. I haven't gotten any records of the city making payments to the nonprofit, which we all know goes by various names: Build Public, Place Lab, Parks Alliance.
Gotcha. Okay, so from my experience, at least my personal experience, I know disbursements are often done by the controller's office. Has anyone reached out to? Actually, this is a good question, I guess, for the for the respondent, Ms. Mizuko. Could you maybe speak to, did you contact the controller or whichever office in the city handles disbursements to try to get this information from Mr. Hooper?
First of all, I need to clarify something. We did, in fact, give Mr. Hooper the payment records. That was in the TGS system, and that was the documents we found post his original request. We were at least in our office, myself and Chris Morgan, who manages that program, that those payments are processed through something called the TGS system. And those are the additional documents that we provided to Mr. Hooper. So in total, we gave him 24, potentially 25 extra documents from the original 1,700 documents that we gave him. I want to also explain something, just really to clarify this. The 1,700 documents that Mr. Hooper received from Mr. Heckel were not new documents. They were, in fact, the original 1,700 that I gave Mr. Hooper. What Mr. Heckel did was he matched them, he indexed them to specific questions that Mr. Hooper provided us post the February meeting.
I understand that.
Okay. So then one last thing about that, Mr. Hooper, Anonymous, and Mr. Sullivan, I believe, have all made requests to the controller's office for those documents. But we did provide Mr. Hooper with the payments, and those were the ones that came through the TGS system.
Okay, so then let me go back to Mr. Hooper. Mr. System in what you received.
No, I do not recall seeing so-called TGF documents that represent records of payment for those two Green Benefit District efforts. And I also, in the format, I think that Ms. Thompson is saying that I should have received information keyed to the 21 revised questions that you asked me to submit, and I submitted last December in response to the task force requirements. I got 1,741 documents from Mr. Heckel, but I don't recall seeing any way of that they were cross-referenced or keyed in any way so that I could easily or in any way see, my question number one, oh, that's how it was answered, that's fine, et cetera, et cetera. I'm a little bit baffled. I'm sure everybody's going forward in good faith, but I don't remember receiving so-called TGF records of payment, and I don't recall receiving the Heckel, the more recent Heckel documents formatted in such a way that they were intended or meant to coincide or reply specifically to my 21 questions. That would be great. Then it'd be much simpler to figure out what may still be missing. But that's my understanding, and I've spent a lot of time going through these things. I think I've been thorough.
Okay.
Can I interrupt for a second? Vice Chair Yankee, I think it'd be better. The task force had asked OEWD to provide this information, Mr. Hooper. The question should be really to OEWD as to if they did so, and it was indexed. Was that provided to us in the record today?
That's exactly what I was just about to ask. If Ms. Mizuko could point out where
absolutely.
documents are.
Sorry, I didn't mean to interrupt you. Yes, actually, I do believe that Cheryl was CC'd on the response to Mr. Hooper, Anonymous, and Mr. Sullivan. But to point Mr. Hooper directly to the documents, one of the documents he's received is labeled SSPA May 2019 008588548. Is responsive document to the SSPA March 2019 0080013 is responsive. So, I don't want to.
Okay. Information to Ms. Could you I mean, to see what those documents, do you know where they are? What page number they're on?
I would actually defer to Ms. Leger because we did send her the complete file, and I will have to. And actually, to be honest with you, as I click on this where it says attachments, it's not opening up for me. But we did indeed document Ms. Leger.
Okay, if I received documents, they were put in a file. There were several emails from Mr. Hell with multiple attachments. They were included in the file. That's all.
Okay, so yeah, the problem here is this is a massive file, okay? And it really, I'm sorry, Ms. Thompson, I'm going to put the onus on you. This is your defense. This is what the task force had requested you to do. And we want to find out, if you're saying that it was done, then we need to see if Mr. Eckel had in fact indexed all the documents based upon the 21 bullet points. Then we'd like to see that. That's why we're here today.
Correct, and we did send that to Ms. Leger.
And can you, fine, but can you?
But I can't. What I'm saying to you is, when I go to your agenda and I click on attachments for my specific item, number 8, it doesn't open up for me.
Okay.
There are items underneath. It says item 8, part 1, part 2, part 3. Do you see that?
I do.
And if you hover over that, they're actual links.
Correct.
And
so let's go back.
Okay. What we're looking for is a page number, because we've got thousands of pages here.
Member Schmidt, I know that what I saw was that Mr. Heckel did, he sent an email answering one of the 21 or two of the 21 at a time, and then he lists the documents that were responsive to that request. And so he did this sequence of different emails, and that's what a lot of these files are that we got in our document compilation.
There's no way to discern what documents apply to bullet number 1, bullet number 2, bullet number 3. That's what we requested. That's what we're asking for here.
Well, that's what I just said. Is that he says he matches each number in a series of emails that were in our documentation. I don't know where. This thing is huge. I didn't mark every one, but I'm saying that they're there.
So this is member Stein. So, can I just say it? Like,
Go ahead, member Stein.
Go ahead, Sheriff.
Yeah, so I'm looking at item 8, part 7. I'm on P2069, and this is a list that I've seen in a few places where you have response to your numbered requests are set forth below, and it has number 1, OEWD is not located responsive files, number 2, responsive material produced at pages, and then it just gives kind of a long list of document pages, but we don't have a way, well, I guess you can click on some of them, possibly? No, when I click on them, nothing happens. And then, the list goes on like that. Which ones were found, which ones were not found.
Okay.
So if you're looking for the invoices starting at item 8, part 6, page 2030, you will find the invoices.
Part 6.
Item 8, part 6, page 2030.
It's not in the right spot.
Glacier Roseway because it's not in its where we responded.
Perhaps you might want to unmute your committee members. Sorry.
Okay, 2030. I'm there. Okay.
I'm just seeing an email that says, please see attached supplemental file, but no attachment.
Right.
Yeah, Mrs. Zuko, maybe you could show us where those, I think you called them, was it a PGS or something? I forget.
PGS files, yeah. I think that part of the problem may be the way that these, I think the problem is the way that this request was uploaded in PDF to you, but the TGS files are in here, or they were in the ones that we provided to Ms. Leger.
Yeah, what we're seeing, if you look on page 2033, that regards or relates to category number 12, the bullet number 12. And if you go to the next page, to 2034, it jumps to category 15. So it's...
Yeah,
and then
I think the way that this document has been PDF'd and presented to you, but the invoices were given to Mr. Hooper and Ms. Leger in a responsive document.
Let's all, while we're on this particular PDF, let's all look at page number 2036. That's PDF page 100 out of 130. Those are the 21 bullet points, and those are the responses for each one of those. And I guess the materials are scattered around this record, this file somewhere. That's dated March 16th, 2021. So,
can I just say, as Member Stein, like I went through this pretty carefully, and I don't recall seeing anything that looked like records of payments that were made from the city to, the Parks Alliance.
Okay.
So I saw many times this list reappear, and in fact, I will also say there were many links that I tried to click on that didn't go anywhere, or that went to kind of dead space, but I don't recall seeing a list of payments.
So the list of payments were included. The numbers that you're seeing, the index that you're seeing on 2036, had this been a live document, those numbers would have taken you to the actual documents. What I'm saying to you is we have provided these two documents, and we've to Mr. Hooper and Ms. Leger. It's that the fact that this has been PDF'd in a way that does not allow you to have been the original recipient of this document to see that the invoices and all the documents are in there.
Oh, so they're hyperlinked?
They're hyperlinked. We did that to make it easier for Mr. Hooper, so that as he looked at a question, like if he looked at question number 21, he could present a hyperlink, which is 00069. That would have provided him. And so that's the problem that we're seeing, is that those documents were provided to everyone. It's just that the way that this PDF, it doesn't allow you to click on those links.
Okay. Member Stein, any last thoughts?
My problem, I guess, is that I feel like Mr. Hooper doesn't seem to have access to these or have seen these, and we can't access them or see them. And is Ms. Thompson able to look at examples of these and read them off to us or something, so that we have some sense of what they contain?
I would probably be better to corroborate it with the petitioner. Did he actually get them?
He didn't see it, and now he doesn't have, tech access. But yes.
But I guess I would ask Mr. Hooper, when he received the response from Mr. Heckel, was he able to click on links and did the link take him to documents?
Exactly.
Because if it didn't, then he should have responded back to us and said, these links don't work for me, instead of waiting till now to say those links don't work. So, Mr. Hooper, was he able to click on those links?
Right. So before I get to Member Schmidt and Member Neighbors, on the other hand, let's get this question answered first. Member Stein, then you can finish up.
Can I just say, if we can also, if Mr. Hooper wasn't able to do that, I think there were two other people who had also requested that data. If we can also ask them whether they received it, if Mr. Hooper did.
Mr. Sullivan is now party to this, so he can certainly answer it, but Anonymous is not party to this, so we cannot ask him. Mr. Hooper, are you still there?
I'm still here, Mr. Chairman.
Okay, so of the email, from the email that Mr. Heckel had sent you, looks like there was an email on March 16th, 2021, where it lists your responses for each of your 21 bullet items. Were you able to access any of the documents that were hyperlinked in that email?
Mr. Chairman, no, and I'm not sure I received the information that Mr. Heckel dug up in an indexed format.
You know what?
It was page numbered. It was paginated, but it didn't. Actually, I didn't even think he was trying. It didn't even occur to me that it was an attempt to answer those specific 21 questions, which we've all been trying to get to the bottom of. So I'm not sure. In a way, it's sort of gratifying that you guys, who are experts on this, are having as much trouble as I am. But I saw it as another, because there have been, a number of different times where first we're told there's nothing more to give you, and then 2 weeks later you get something more. I thought this was just another of those situations where the city had come up with additional information that it hadn't realized was pertinent or hadn't disclosed earlier. So I can't say I understand or did grasp that Mr. Heckel was formatting his 1,700 documents in such a way that they were intended to represent answers to specific questions. I actually went through an exercise myself of going to and saying, well, is this responsive? This is irrelevant. I've seen this twice before, and so on and so forth. So anyway, I apologize if I'm being dense about this, but
no, it's not that. We're getting closer, but we're all a little confused. I just want everybody to notice that on these emails from Mr. Heckel to Mr. Hooper, that they are referencing emails that were being sent to someone else. Someone called Mayor Sunshine Requests that's a general. Someone called A Records Requester at protonmail.com. That is not Mr. Hooper. And so all of these that Mr. Heckel is sending to Mr. Hooper are messages that he sent to somebody else that he then forwarded to Mr. Hooper. And so I'm wondering if at that point it made it so difficult to track for Mr. Hooper. I'm not sure, and that's what I'm trying to ascertain. Let's go to Member Schmidt, then we'll go to back to Vice Chair Yankee. You're on mute.
I guess you're done on that line. Okay. I've got a couple of somewhat of a shift here. To Ms. Mazzocco. First, are you saying that you sent the TGS documents that would be responsive to Mr. Hooper's requests to him already?
What we're saying is the TGS documents are, in fact, the documents we found after Mr. Hooper's original request.
When did you find them?
We found them when you asked us to go back and index the records for Mr. Hooper. We found them in that process.
Okay. So the TGS documents you then did produce to Mr. Hooper in 2021, is that right?
No, there was an original Sunshine request in 2019, and then these were additional records in 2021.
2021, okay.
Yes. And I believe that Mr. Heckel just resubmitted these documents, just replied to Ms. Leger so that she can see the 21 records request and how it's connected.
Okay.
So,
well, make it brief, please.
Well, so Mr. Heckel just sent all of these, resent them to Cheryl, Mr. Hooper, Mr. Sullivan. And to clarify for you, the Proton email that you are referring to was from Anonymous. That is Mr. Anonymous's email address. Post the February Sunshine Task Force, Anonymous helping Mr. Hooper to get clarity on his questions, resubmitted Mr. Hooper's questions in 21 points. And that's how we responded to both inquiries, because they're the same inquiry. They're from Anonymous and from Mr. Hooper.
So what you gave to one, you gave to the other, correct?
Correct.
Okay, great. Now, I've got one other topic I want to ask you about. The OEWD does business with the Parks Alliance, correct?
Yes.
Okay. And there are contracts that are signed between the OEWD specifically and the Parks Alliance, correct?
Correct.
Okay. And Parks Alliance is it anything different than what's called Place Lab and Build Public, or are they all sort of the same thing?
To provide clarity, Place Lab is the original contract holder.
Okay.
It was a nonprofit that supported public space, it supported public space, and it's no longer in existence.
Okay. Now that the Parks Alliance, have you ever made yourself with Parks Alliance to ask them for documents to respond to the Hooper requests?
Yes, we did, and those documents were given back in 2019 to Mr. Hooper. We reached, based on what the Sunshine Task Force asked me to do in 2019, we went to the Parks Alliance and asked if they had any additional documents, emails, other than what we currently had in our files, and they did not.
Okay, so did you show them the text of Mr. Hooper's requests that were made to OEWD at that time?
Yes, we did. And this was all addressed in a previous Task Force meeting in 2019, and it was decided then that we could not compel Parks Alliance to give us any additional documents. And I had reached out, and I made this presentation at the task force 2.5 years ago and said I reached out to the Parks Alliance and that they said that they had given me all the documents that we had. So all the documents they have is what we have. All the emails that we have is what they had. And they had no other additional documents. And this is a very different line of question from what we are here to respond to today.
Well, I'm sorry. Please don't tell me what to ask you, okay? Because this is very important in the case. The Parks Alliance documents you're talking about in 2019, was that the Hooper case or was that a different case?
Yes, that was Mr. Hooper and Mr. Sullivan.
Mr. Sullivan. Okay, so that wasn't...
That was Mr. Hooper and Mr. Sullivan.
Oh, they were together at that time?
They've always been together.
Oh, they've always been together. I see.
Mr. Hooper, Mr. Sullivan, Mr. Tomasevich, and Anonymous.
Okay, but who decided that Parks Alliance didn't have to give up any documents? Was that you?
When I presented to the task force, and you had received a legal opinion from one of the city attorneys, and I said that I had made every effort to get those documents, and if there were any additional documents, and Parks Alliance said that they did not have any additional documents, that was the task force.
So, but why would anyone have said Parks Alliance doesn't have an obligation if they were actually giving you everything? How would that have happened? I don't understand.
The task force asked me to ask the Alliance if they had any other additional documents over and above what OEWD had.
Okay.
We went back to them and we asked them, and they said no, they did not.
So they didn't say, so nobody in this whole process said Parks Alliance doesn't have any obligation. Because I thought that's what you just told me. That someone said...
The task force had decided that, I believe the task force decided that 2.5 years ago in a previous hearing.
But they said that Parks Alliance doesn't have an obligation, but Parks Alliance would have an obligation to OEWD if OEWD asked, correct?
Correct, and we did.
Okay, that clarifies, as opposed to a request made directly to Parks Alliance. Okay, thank you. I have no further questions for the witness.
Okay, great. Member Stein, did you have something else to add? Or Member Neighbors? Go ahead.
I don't think I do. This is Member Stein.
Okay, Member Neighbors, you had your hand up before. Did you have anything you wanted to ask?
No, it was covered. Thank you, though.
Okay, great. Has everybody gotten everything they need? Okay. Can we, so at this point, Mr. Hooper, are you still there?
Yes, sir.
Okay, so at this point, the question becomes of the emails that you got from Mr. Hill. There is in some of them attachments, and some of them have actually an index from 1 to 21 with responses for each of those 21 items that we requested to be made. And in those, there are links in there that you can click on to download those items. Do you recall seeing those?
No, it sounds mind-bogglingly difficult. I do not recall seeing those. Unfortunately, I don't have electricity, so I can't go to my desktop and verify. But have you been able to do exactly what you're describing?
Well, we see the emails. We don't see we cannot check the attachments, but we're not so concerned about the attachments or the records, except for the ones that you're concerned about. So we just want to make sure that you received all the documents that you requested. Ms. Thompson claims that everything has been provided, including the contracts and the accounting. So that's what we're trying to ascertain here at this time.
Yeah. The same thing. Do you want me to respond?
Well, the question I have here is, these are emails that are being sent on a regular basis to you. June 11th, June 14th, this is 2019. Then jumps to May 3rd, 2021, and then another May 3rd, another May 3rd, and another May 3rd. I mean, it goes on and on.
Well, maybe there's another way of looking at this. Is there a lower technological method? I mean, we used to send things to one another called letters. I wonder if rather than hyperlinks and, all this kind of thing, since apparently OEWD is making a good faith effort to get the data to me, and they are convinced that I really should have it all, and
maybe it's as if somebody sent someone a response to a question they'd asked, but they sent it in a language the person didn't understand. The person might say, well, I really did that in English.
Okay,
and maybe that's where
go ahead.
giving.
Okay, go ahead.
You want me to?
Yeah, go ahead, finish, Mr. Hooper.
Well, I just wanted to say that I certainly give the city agencies all credit for proceeding in good faith, but, if it's really just a matter that I can't open a hyperlink or I don't understand what EGF is, or isn't there a simpler way? Just print the stuff out.
You're going to be charged for it.
Oh, big deal.
Okay. Member Stein.
I've spent 2.5 years on this.
Yeah, this is Member Stein, and I feel like I'm getting hung up here because I'm trying to understand if really the documents that are on hand or should be on hand have been delivered, and because of our PDF we can't tell, and because of the power outage and the hate, Mr. Hooper can't tell. So I'm wondering if Ms. Leger has the original things that were sent to her before they were PDF'd, and if she can maybe share with us what she's seen, or if, I guess it's Ms. Thompson, I'm a little confused who the respondent is, if she has the original documents and can drop us a link to them in the chat, or if there's any way for someone who might have access to these pre-PDF'd actual documents can, because I'm on Zoom calls all the time, people drop links into chats that we can all then go and check and see what's there. Can Ms. Leger or Ms. Thompson or Mizuko do that? No.
Yeah, I don't think that's
very hard for us to decide this case if we don't know if the information has been delivered or not.
I don't think it's going to be helpful to have
Ms. Leger was just sent all those links and all those documents from Mr. Heckel. So if she is near her desktop or her computer, she can actually go through it. He was gracious enough to actually format for her so that she can see which were compliant. So, for instance, Mr. Heckel just sent Ms. Leger an email, and it's the heading is Forward GBD Paper Trail 19061-19062. And again, she does have those.
Marianne.
Pardon?
You get that email? Forward.
Oh, he just sent it to he just.
I'm going to interrupt this for a second to take Vice Chair Yankee's hand. Mr. Sullivan is party to this. Mr. Sullivan, did you get these records?
Okay, yes, I got some. I'm looking at right now, and they're not in the packet.
No, we're talking about, did you get the actual email of these documents, not what's in our packet?
Yeah.
Okay, can you confirm getting the records that Mr. Hooper is looking for?
I can confirm I have records of transaction voucher ID and invoice numbers with numbers that came from OEWD and Mr. Heckel.
Does that include invoice amounts?
Yes. So we have payment date 4/23/2019 for $45,650 USD from Bank of America.
Okay, I'm looking at an email that I just received from Hank Heckel. The payment records copied to Mr. Hooper, the task force, and Mr. Sullivan on May 25, 2021. Would you like me to forward it to everyone?
Yes, please. Okay, Member Yankee, Vice Chair Yankee, go ahead.
Yeah, I was just going to note that and this might be part of the problem. I was looking at page 2036. And this is one of the various emails. Looks like was sent with the 1 through 21. I noticed that one of the sentences in there says the responsive materials be provided through an FTP link with associated credentials. And so I don't know if there's like some type of login password or something that may have been a separate email that maybe Mr. Hooper didn't receive, or how it worked. But it sounds like it might be more than just clicking a link. It looks based on associated credentials. And so
look at the headers above that, and you'll see that that particular email is forwarded to Mr. Hooper.
Yes, I wonder if the actual credentials were ever sent to Mr. Hooper, because it looks like it was a forwarded email that was sent to Anonymous, and if Mr. Hooper never received the associated credentials, he obviously could look at them.
Exactly.
He didn't need credentials to look at them. He doesn't need credentials to look at them.
Okay.
What it basically is saying is that we are allowing you access to a file that sits in one of our shared services. That's what that is saying. He doesn't need a credential. He doesn't need a password. It's just the saying that we are allowing you access to a file that sits in one of our servers.
It would have been good just to say that. Associated credentials means, and I'm a chief information officer.
There was one email that Hackle said that you had to get a code to access the documents, and I took screenshots of that. That's how I know the invoices.
Okay. All right, folks. We are way over time on this. Are we satisfied with the discovery portion here at this point? If not, let's consolidate and get to it. Yeah, I've not received the email yet either.
I sent two, Bruce. Both of them from Hank Heckle.
Yeah, I haven't received either.
I haven't received it.
They're large files, I think.
May not be able to receive it then. Email will only allow up to maybe 20 megabytes or so.
It would have sent Ms. Leger a message that said this file is too large to send. So the thing about Microsoft is that it won't let you send a document. It won't let you send it if it's too large. And it bases it off of understanding its knowledge of other people's email capacities.
Okay, now I got it.
Somebody got it.
Yep. So this is going to take a while to download. Gallery. It says I need a passcode.
I think you can just, this is not wrong, I think you can just get one sent to your email.
Right. Yeah.
I did with Google and it let me sign right then.
It just says that I need a one-time passcode.
Yeah, it'll send it to your email address where you received the email.
I see.
I was just going to bring up one concern with the way we're approaching this, in that these records that are being emailed to us now have been made available to the public. I don't know if that's a concern for us, as they are.
Well, supposedly there are records that were supposed to be that were sent to us properly with hyperlinks in the forwarded emails, but got stripped out through the scanning process. So yeah, I hear what you're saying. I'm not sure how to, what to do about that at this point. If you want to stop and not consider this, then say so. I would, if we can, if you make an active statement or request, then let's do that. If you feel uncomfortable about the way we're going about it.
Were these not already a response to a public records request and therefore public records?
They were part of emails that were sent to numerous people.
Well, I mean, I thought they were sent as a response to a public records request.
Yes.
Ergo, they are public records.
Yeah, but Member Wong is suggesting that if they, as part of our hearing, if they weren't part of our record, then there are other people here at the meeting that have a right to see those as part of the record. So if we're the only ones that get to see it, and Mr. Hooper can't even see it, then that's the problem here. So
can we not drop these links into the? They might not have the chat access.
No, they don't. Everybody else is called in by phone.
Right.
And Mr. Hooper has basically expressed that he has some technology difficulties, possibly in tracking these down. So the question I would say here is, Member Stein, you had the question of whether there were, you wanted to see the invoice voucher number or vouchers. Are these the documents that you were looking for? If they are part and parcel to the emails that were sent to Mr. Hooper or forwarded to Mr. Hooper and were sent to Anonymous, a records requester at Proton Mail. If those emails that Mr. Hooper would receive actually retained the links in them, then he should be able to see what we're seeing right now.
Mm-hmm.
Okay, Member Wong, does that satisfy you?
Perhaps. I just worry that folks who are part of the public that aren't party to this case may not be able to make, the comments that they'd like to make with the same level of accuracy that we would be allowed to, as members who can see some of these documents and or folks who are party to this case. So
well,
I would say I still have concerns around it, but
I would say if that is a concern and it's a concern of the task force in general, then I would say we continue this item so that it can be redistributed in the record. And because right now we're going on over an hour on this, and we have one more that is similar to this. So just in a matter of time. Okay, I have Member Neighbors, then Vice Chair Yankee. Member Neighbors? Member Neighbors?
I don't have my hand up. Do I?
Oh, I thought you had your hand up. I'm sorry. Vice Chair Yankee.
I think that Member Wong's point is good, but I'm not necessarily sure that we even need to look at the records for this stage. I think it's already been admitted that certain records were not initially turned over in the last 2.5 years. I don't think that even OEWD is disputing that at this point. And so I think just based on the testimony alone, I'm thinking that there's enough to find a violation because, obviously here we are 2.5 years later, and we're now finding out that additional records did in fact exist after being told multiple times they did not. And so my line of thought to see what anyone thinks here is that perhaps we finally find a violation here, and since I think that's very clear that there was one, then we send it off to compliance and amendments, and then make sure that all of these files that we're speaking of now that didn't make it into the record are included into that agenda for compliance and amendments for follow-up to make sure that Mr. Hooper can then access those new files that he wasn't able to see prior to this meeting. That would be my suggestion.
That's a good suggestion, but you got a little ahead of the bus here.
I know, I'm sorry, because I know we were talking about the and that's the only reason I went there.
I got it. So you probably need to repeat that after rebuttals are over.
Yeah.
So we can arrive at some decision. I appreciate that. Thank you.
I didn't want to continue too early.
I got it. It's all good. I hear you. Okay. Any other questions for the parties here regarding the discovery? Any other information you need to be able to arrive at some conclusion? Okay. Is there a call for a continuance necessary or not? No? Okay, then we'll move to rebuttals. Ms. Thompson, you have 3 minutes for rebuttal. Wait for Ms. Leger.
You ready, Marianne?
I sure am.
Go ahead.
I have no rebuttal. I'll take the violation, and thank you all for your time this evening.
Mr. Hooper, please wait for Ms. Leger. You have 3 minutes.
Go ahead,
Standing
sir.
by.
Go ahead.
Thank you. Thank you. Mr. Chairman, members of the task force, I think it's well nigh time that a violation is found. I would urge you to move ahead in the direction of the task force member who just suggested that. And I think that would move things in the right direction. I do think that just as a matter of policy for all of you to consider, that I don't think we want to get to a point where the only citizens who have a right to transparency in their city government are those who have an internet technician standing by their side, or a staff that can, I'm noticing it with some, frankly, gratification that you're all having a lot of trouble with this. You're the experts, and I'm just a member of the public. And I mean, I use email and I, go to use FaceTime and stuff like that. But I mean, if everything you have to access requires hyperlinks and special passcodes and layers of, confidentiality, it's almost as if you're just going to provide the information in a language that the person who is interested doesn't understand. So I think part of the problem may just be one of, let's keep it simple.
Okay, thank you very much. Okay, members. Now, Vice Chair Yankee, you can launch.
Okay. I'm not sure I have much more to add, so I'll just elaborate. Just for the record, though, I find it, I certainly feel Mr. Hooper's frustration. We have all met on this multiple times. We've gone to the task force, I think at least full task force, 3 times at least, several committee meetings, and Mr. Hooper, all along the way insisted there were more documents, and sure enough, there were. And I think that's, extremely frustrating for a member of the public to have to go that long to find these records. And so I certainly do think that there is a violation here. At a minimum, I'm seeing 6721B, because obviously it says within 10 days, and here we are a lot more than 10 days later. I guess I'll go ahead and throw that out there. I can make a motion unless anyone else wants to add or has additional points they want to bring up. No?
Any other discussion or comments? Okay.
All right, so I'll go ahead and turn my proposal into a motion. I'll find a violation of 6721B for not supplying the requested records in a timely fashion. And I would also recommend this be referred to the Compliance and Amendments Committee for follow-up, and to ensure that Mr. Hooper can, use the links to obtain the invoice and other information that he was unable to view prior to this full meeting, and to have those records included in the agenda packet for that Compliance and Amendments Committee, so that they're public record before Compliance and Amendments meetings.
Before there's a second, I want to ask if you'll take a friendly amendment that since Mr. Sullivan has stepped up to be party to this file now, that he also helped Mr. Hooper.
Yeah.
I find him, because it seemed clear to me that he was looking at one of these documents, invoices. So
yeah, accepted. So that's my motion.
Is there a second?
This is Member Padmanabhan. I will second that.
Okay, moved by Vice Chair Yankee, second by Member Padmanabhan. Any further discussion? Okay, let's open it to public comment. Cheryl, hand it off to you.
This is anonymous number 3, if I may speak.
Yeah, just a second. Go ahead, sir.
Thank you very much. I am the anonymous who received these records originally. I'm going to tell you the real story because Ms. Thompson has misled this task force, which is really infuriating. Ms. Thompson and Mr. Steinberg told this task force and Mr. Hooper at the committee that they refused to do the indexing by 21 items that he had asked and that you had told him to do because he had not separated which of those were and were not already provided to him. So what happened at the end of that meeting, that committee meeting, is I issued 21 records requests to DPW and OEWD to force them under the CPRA to tell me which of those had records and where they were, which they did do. They did not do it when you asked. They did it because I issued separate 21 records requests in February. They then responded to my requests. They did not provide any index, or they provided an index, but they did not hyperlink. That's not true. That you can't go find out which of those records. You have to go through the page numbers. Their own system, me as a person who runs a computer software company and has done software engineering for years, I could not figure out initially how to get access to those records until it took some time to figure out how to do that. It is also the case that the records that weren't given were not because they put in the work. It's because I found the system called Total Grant Solutions in their website, which is their financial tracking system, and I told them, hey, even in my request, you did not provide these records. Now go search those in April. And then they provided them to Mr. Hooper, to Mr. Sullivan, and me. And there was another set of records that they didn't provide until I demanded, which is the January 22nd, 2019, which predates his very first request, attachments, funding requests, deliverables, email threads between them and Parks Alliance. And that was not provided either until I made the records requests. And this should never be acceptable, that you just need some other person to come and barrage the city with more records requests until they do a full search. It is unacceptable that OEWD apparently had not fully searched their own financial tracking system, which is what Total Grant Solutions is. And you can see that all in the email threads. It's all in the back and forth. This violation is absolutely appropriate, but it's frustrating that Ms. Thompson isn't giving you the full story of exactly how they got to even finding these records. Thank you very much.
More public comment also, please.
Mr. Warfield.
And I'd appreciate a 30-second warning. My timer is unavailable right now. Let me know when to start, please.
Go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this, excuse me, but we do have, as usual, a strong interest in sunshine because we have certainly benefited from sunshine and from the task force's many findings over the years in our favor with respect to difficulties in getting information. First of all, I want to congratulate and thank Mr. Hooper for his evident persistence. Second, just so you know, technical problems, I tried to hover over any part of this item and the next one and could not see, well, there was no link.
Welcome to the audio conferencing center. Please enter a conference ID.
This meeting is being recorded and or transcribed.
And basically hide information. And one of the most difficult things is links. I've gotten links to something that supposedly went away sometime before I looked at it. I've gotten links that don't say where I'm going, so I'm clicking blindly into who knows what place. That should not be appropriate or, well, considered an answer. And finally, the idea that Mr. Hooper was getting into some place that was their cave of information, that is not the same as supplying somebody with the information so they can have it, keep it as long as they want, do with it what they want, and so on and so forth. So I think there are some serious issues here. I would certainly say next request is an example of obfuscation in responding, but this is a very interesting case. I'm glad Mr. Hooper pursued it. Certainly support the motion. Thank you.
Is there further public comment?
Last call for public comment. Okay. Well,
Bruce, you muted yourself.
Sorry. Are there any last comments? Hearing none, are we ready for a vote? Okay, let's call the roll, please.
Member Yankee?
Aye.
Member Yankee, aye. Member Padmanabhan? Aye. Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley is absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721B for not supplying records in a timely manner and to have the matter followed up with the Compliance and Amendments Committee. So, and that the record should be provided for that committee.
There was also an additional amendment that the other person in this party, Mr. Sullivan, would assist Mr. Hooper.
Got it.
And that's not an order from Mr. Sullivan. That is, he's party to this. If he so wishes, we would be delighted if he would help.
I will help.
Thank you. Okay, let's go to our last item, next item, our last hearing.
Item number 9, file number 19062, complaint filed by John Hooper against Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. Shall I read the preamble?
Please.
October 20, 2020, Complaint Committee determined the records are public and referred back to the task force. On December 2nd, 2020, the task force requested that Mr. Hooper produce the same records list as provided in 19061 to the respondent and referred to the Complaint Committee to review and ensure that the petitioner receives his records. On February 16, 2021, the Complaint Committee referred the matter back to the task force with a recommendation to find no violations.
Okay. Complaint Chair Schmidt.
Yes. Again, that's February 16, and I think that maybe that was that same hearing where Member Yankee was there, Chair Wolf was there, but it was the chair. The regular chair was Chair Hinsey, and I think maybe you two were the mover and the seconder on the motion to recommend, and so I certainly want you to be able to respond to it. Although I will say that I don't at this point stand by that recommendation based on certain documents that I've seen come out in the interim. But if you all have any ideas about that, go ahead.
Okay, I think what might be helpful and important here is it's a very short paragraph for the minutes of that meeting, just so everybody can get up to date on it. I'll just read it into the record. John Hooper, the complainant, provided an update on his complaint and status of the document's disclosure. Mr. Hooper stated there is some confusion regarding a custodian of records responding on behalf of two departments. Mr. Hooper stated that he did not receive the requested invoices, records of payment, and other requested documents. David Steinberg of Public Works, the respondent, provided a summary of the department's position. Mr. Steinberg stated that Mr. Hooper did not provide a list of specific missing documents, but instead provided a broad list of missing document category. Mr. Steinberg stated that reference invoices, presentation, other requested, records are present in the task force packet. Mr. Steinberg stated that Public Works does not have invoices as they do not have a contract with Parks Alliance, and assumes that OEWD, the contracting department, would have the invoices. The action was moved by Member Yankee, second by Member Wolf, to refer the matter to the task force with a recommendation of finding no violation. So that's it. This particular one is now against Public Works based upon the findings of the committee. Okay. Are we ready? Is the respondent, the petitioner here, Mr. Hooper? You still here?
I'm here, Mr. Chairman.
Okay, great. Glad you still have some battery left. And is there a representative from Public Works?
Oh, yeah, I'm here.
Who is this, please? Your name?
David Steinberg.
Okay, Mr. Steinberg.
David Steinberg.
Okay, so let's begin. Mr. Hooper, you have 5 minutes for your opening testimony. Wait for Ms. Leger.
Thank you, Ms. Yes.
Are you ready, Mr. Hooper?
All ready.
Go ahead.
Thank you, Mr. Chairman, members of the task force. I've submitted detailed information to you earlier, which you accepted at your December 2nd meeting. That is, this effort was a government effort by two entities, OEWD and DPW. DPW provided a great deal of the funding and did a lot of the legwork. OEWD happened to sign the contract, but was also involved organizing meetings of neighbors, doing footwork to promote the campaign to privatize city services. And the only thing I would have to add, which is what I've already said under 1906-1 before, is in the technical disclosure, we just have a little bit of further elaboration. Again, OEWD's representative stating to a Rec and Park employee, the GBD program is run by Department of Public Works. That's a heckle page 1389. Again, Ms. Fergus, OEWD, being asked who questions and billing should be sent to. I am merely a conduit for a grant to get through. Jonathan, meaning Jonathan Goldberg, DPW, would be a better person to ask. This was a question about billing. So I just think it's very hard to Two city agencies were very integrally involved in this. I'm done. If you're telling me I'm out of time, I'm done.
No, we did think you may have dropped out there. That's why I was.
I think we didn't hear your last sentence, sir.
Oh, okay. Well, I guess if you can hear me now, I was just trying to say that you already had enough information so that at the December 2nd meeting, you, in my view, accurately determined that both city agencies, OEWD and DPW, are responsible for getting the information the public has asked for, the public information that was asked for. And I'm just giving you some more information that makes that even more abundantly clear now than you had in December, that DPW is much too up to its ears in this program to say, well, we didn't sign the contract, so we have no responsibility. If you have a full-time employee, if you provide the funding, if OEWD points to you every time somebody asks a question, it's hard to figure out how you can't somehow be responsible for responding to the public's questions about this issue, about this program.
Are you through, sir?
Oh yes, excuse me, I'm done.
Okay, thank you. Are any persons or witnesses providing facts or evidence on behalf of the petitioner or the complainant?
Sullivan.
Okay, Mr. Sullivan, go ahead. You have 5 minutes.
5?
Talking
Yes.
to Public Works' responsibility to get records from the contractor or another department. Public Works funded most of the contracts for GBDs, 84% of the last contract. In the contract and acknowledged by Public Works next request 20-4913, the Public Works GBD program manager was the approval manager in the contract's Appendix C, saw and could get all records. He was the central contact person with SF Park Alliance contractor. People versus Ashley, 1954. It should be and is an established principle of law that the substance and not mere form of transaction constitutes the proper test for determining their real character. If this were not true, it would be comparatively simple to circumvent by sham provisions of statute framed for the protection of the public. This the law does not permit. In this case, OEWD would be the mere form of transaction, as in contract, and the substance is Public Works money and the GBD program manager giving approval of work for dispensing of that money. This is the substance that constitutes the proper test for determining. If allowed, the circumventing of who clearly is responsible will happen again and will probably be more complex, further eroding public access statutes framed for the protection of the public. Your decision is about protecting public access. Not holding Public Works responsible is allowing a department to circumvent responsibility for their money and program. Public Works under 6721(9)(c) should at least assist the requester to get records from either OEWD or a contractor if those entities do not fully cooperate. In my opinion, the task force often gets too caught up in the form of how something is presented and ignores the substance of what is happening or has happened. Words can be twisted, actions almost always tell the true intent, and money trail is clear path. Thank you for your time.
Thank you. Any other persons or witnesses providing facts or evidence on behalf of the petitioner? Okay, hearing none. Mr. Steinberg, you have 5 minutes for your opening testimony.
Thank you. Chair Wolf and task force members, my name is David Steinberg. I'm custodian of records for San Francisco Public Works. As you are aware, this is the third time I've appeared before the full task force regarding Mr. Hooper's complaint, and nothing has changed in all that time. Public Works has provided to Mr. Hooper all of the responsive records in our possession. Mr. Hooper repeatedly raises issues that are not germane to his request or to our obligations to respond to that request. In a statement to the task force, which you can read on page P2573 of your packet, he writes that although it is true that OEWD contracted with Parks Alliance to promote GBDs, should Public Works be absolved of any responsibility to help provide complete information? End quote. We've never disputed that we have a responsibility to help provide information. In fact, we did fulfill that obligation by providing all of the records we had and repeatedly appointed Mr. Hooper to OEWD for any remaining documents. Mr. Hooper asked that the task force find a violation and order Public Works to produce relevant information. We can't produce something that we don't have access to, and don't have a legal responsibility or ability to obtain. Public Works has complied with the task force's instruction to provide all records requested by Mr. Hooper that are in Public Works' possession. Approximately 240 pages of documents directly, and an additional 600 documents through a link to a previous request. I ask that you follow the recommendations of the complaint committee and find no violation in this case. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members? Vice Chair Yankee.
Thank you. My question is for Mr. Steinberg. Do you or does Public Works have access to the TGS system that we discussed in the prior case where invoices and disbursements are recorded?
I've never heard of it before, so I don't know.
Okay. That was the other question I had.
Member Stein.
Yeah, I have a few questions for Mr. Steinberg. Did the DPW, to your knowledge, give money directly or indirectly to either of these GBD projects?
From the records I've seen, it appeared that some money from Public Works was transferred to OEWD that was used, I believe, in the contract that OEWD had with the various nonprofits.
Okay, and then you also did have a managerial position that was overseeing the GBD project?
We formerly had an employee in our community outreach group whose job was to work on GBD programs. Yes.
Okay, and is it
he's no longer with the department.
Is it typical for DPW to be overseeing and funding programs and private entities that they don't formalize through contractual obligations?
I wouldn't know how to answer that. It's not my policy area.
Okay, because I mean that to me is a key question here. And then I noticed that there are now some GBD contracts with an organization in the Dog Patch and with an organization in Northwest Potrero Hill that are between the DPW and these GBD projects. Why would some GBD contracts be through OEWD and some through the DPW?
I couldn't tell you exactly why certain decisions were made, but I can explain a little bit. The Dog Patch GBD is the only established GBD in San Francisco. And under the legislation that was passed by the Board of Supervisors, GBDs have certain obligations for reporting, and Public Works is essentially the monitoring agency for it. So as an established GBD, they have to produce a yearly report, and we have to provide it to the Board of Supervisors and things like that. The groups that Mr. Hooper, Mr. Sullivan, Mr. Tomasevich were asking about were never, they never came to fruition. They were community individuals who were investigating the idea of starting a GBD. Parks Alliance, Build Public, and I'm blanking on the third one's name. Place Lab. They were contractors of the city who were helping community groups investigate the idea of formalizing and forming a GBD. But the only one that actually made it to that far was the one in Dog Patch, and under the legislation, Public Works is responsible for monitoring those districts. I'm not sure if that exactly answers your question, but maybe.
Yeah, I guess I'm trying to understand as a person who's not associated or doesn't know that much about DPW and OEWD, why the same kind of program, just because it's in a different neighborhood, would be administered by either one of those agencies, and why it doesn't fall under the heading of one or the other to oversee those programs.
I couldn't give you a definitive answer. I mean, I could speculate that it might have to do. I mean, anything from politics to where money is available to, who knows what. I mean, one of the, Anonymous, as he pointed out, is submitted records requests related to this as well, and he showed that Public Works did have a contract with. I think it was Build Public or Place Lab, and that happened to be for the investigation into possibly setting up an Inner Sunset GBD. Again, I can't tell you why one would have been OEWD, one would have been Public Works. Other than I think in one of the cases, what a former supervisor had access to a pot of money that he wanted to use in his community, and neighbors asked, about working on possible GBD, and so the ad backs were sent to the Department of to investigate it. But I couldn't tell you exactly why. That's not my area of expertise.
Yeah, I'll just follow up and say that I did look at one of the contracts that was referenced, I think, by Anonymous in the documentation, and it was a full contract with the GBD, but it was for Dogpatch and Northwest Potrero Hill GBD. But anyway,
yeah, because that one actually does exist. Yeah,
right. That's
an actual established one. Yeah.
Those are my questions.
Okay, and Mr. Schmidt.
Okay, also for Mr. Steinberg, I just want to confirm, I think we talked about this before, but nobody at DPW ever asked Parks Alliance to give documents in response to the Hooper requests. Is that accurate?
That is correct. As I said, we provided all the documents we had, and then we told Mr. Hooper and Mr. Tomasovich and Mr. Sullivan that if there were other documents, we have a duty to redirect, and we, they were already in contact with OEWD, so we told them they might be the ones to have it because again, we didn't have the contract with Parks Alliance.
Okay. And so you deemed it that you would redirect them to OEWD in order to get anything having to do with Parks Alliance, correct?
Yeah, I mean, honestly, again, we didn't have the contract with Parks Alliance, so I wouldn't even know who to go to at Parks Alliance to ask if they had the records. And from for 2.5 years through this journey, my understanding is that OEWD had made that request and have gotten, what they produced what they had or what they could, and they had the contractual relationship with Parks Alliance.
What is it specifically that OEWD requested and obtained from Parks Alliance in terms of documents in response to the Hooper request?
The only things I know is what I've heard by attending however many hearings, 6 or 7 hearings that I've attended, that Ms. Thompson has spoken about.
Okay, so it's based on what she said that happened. But it's your belief that despite the working relationship on the GBD issue between DPW and Parks Alliance, DPW can still just tell Hooper, no, you got to ask OEWD if you want anything from Parks and Lines.
Well, we gave him everything we had, and when Mr. Goldberg was in the department, I asked him, and he produced lots and lots of documents for me, including lots of emails, and I had our IT folks do it. Again, our obligation to fulfill the request was to produce what we had, and if we didn't have it, to tell the requester where we believed he would be able to find it, which is what we did.
Okay, that's all for now. Thank you.
Okay, Member Stein, did you have your hand up again? No? Okay, Member Neighbors, go ahead.
Thanks. Just to clarify, Mr. Steinberg, just to make sure I'm understanding this, but even though the responsibility and the documents were shared, when Mr. Goldberg was still with you, he was the Green Benefit District Program Manager, right? So in a sense, he was the only staff member for the program and managed the program out of your office, right? Is that right?
I'm not sure if that's an exact characterization. So again, the only established, voted on, approved by the board, approved by the voters, GBD is Dogpatch, and it has its own nonprofit and its own executive director and its own staff. Public Works' role is to monitor and do certain oversight. It has certain oversight responsibilities that the Board of Supervisors put into the law, which includes, as I said, getting an annual report, producing that report to the Board of Supervisors and things like that. The other parts of Jonathan's job, he did community programs, so that was everything from monthly neighborhood cleanups in all the districts to helping work on different projects in the supervisorial districts and things like that. And he was also the GPD manager. And that mostly meant working with community individuals who were, interested in trying to set up or investigating setting up green benefit districts. And so he would help those community members with things like setting up neighborhood meetings, helping to, and this is all based on the thousands of emails that I've read and had to review. Hosting community meetings, doing presentations, meeting with different neighborhood groups, things like that. So it was kind of a community outreach role, I guess you'd say.
Okay. That's how I read it too. Thanks.
I have a few questions myself. Mr. Hooper, you mentioned that in your opening testimony that there was some admission made by, I believe, I think it was Mr. Apple with a page number. Can you give that to us again?
Were you asking? I had found in the recent Hank Heckel information some new emails that contain from OEWD's employee Chris Kohrs, which I quoted earlier. I'm looking for them now as we speak. I think that's what you'd like me to.
Yeah, no, I want you to. If it's in our record, if you can just give us the page number.
Oh, it's in the statement that I gave you. I don't have it in the record I submitted to you a week ago in anticipation of tonight's discussion. I give you chapter and verse using not your pagination, but Heckle's pagination. So, for example, at Heckle page 1389, Chris Korkus of OEWD writes, the GBD program is run by Public Works. This clarification is reinforced in several other points, which I then quote at page Heckle 1566, Heckle 1579, and so forth. And those were the ones that I thought would further amplify the point that you found compelling enough back in December to require that DPW remain integrally involved in helping get to the bottom of this. I don't think that Mr. Steinberg's assertion that he gave everything in our possession really does the trick. The real issue is that the work done by the third-party contract party, in this case Parks Alliance, belongs to the city. And one of the city agencies, absolutely up to their ears in involvement, is DPW. And so that's why I think you were correct back in December when you chose to realize that it was a multi-agency effort and it was appropriate to keep DPW involved. And in my judgment, you misunderstood the situation in March when you contradicted yourself and released the Department of Public Works from further responsibility. I think they bear a further responsibility.
Okay, can you give me the name of the parties in that message again? Because I'd like to see it. I'd like to see that document or those references, and if they're in the records that you submitted for this hearing today, I think it might be helpful for us to ask for.
Sure. Thank you. An employee of the Recreation and Park Department wrote wrote OEWD on the 2nd of January 2018, asking about getting involved. Her name is Beverly Ng. Her last name is spelled N-G. And she works, or at least then worked, at the Rec Park Department. And she asked about getting involved in the Mission Dolores, the then beginning campaign by the city to convince neighbors to set up a GBD in the Dolores Park neighborhood. And because Dolores Park was potentially involved, Beverly Ng was interested in possibly having her department involved. When she asked Chris Korkus who to go to, his answer was, the GBD is run by the Department of Public Works. And that's at Heckle 1389.
What's 1389? Is that a page number?
Yeah, in the Heckle emails, they are numbered in a different way than your own in your own reading file. So in the Heckle emails, once you get there, it's probably pretty easy. But you would go to page 1389 of his 1,741 pages, and you would find that quote between OEWD and Rec Park right there.
If I could jump in real quickly, it's 2544 on our...
Yeah. 2544.
Yeah.
Yeah, I'm sorry, I didn't have access to a computer to get your pagination. And then again,
hold on a second. Is that in item 9, part 6?
Part 5.
You guys?
Part 5. Part 5.
I'm sorry, and the page number again is?
2544.
Okay. Okay, I don't need any further explanation, Mr. Hooper. That's all I wanted. I wanted to make sure that it was here.
Sure. Well, thank you, Mr. Chairman. Just for clarification, in my written statement I submitted for tonight, but I submitted it a week ago to be timely, I do provide some additional page numbers, Heckle page numbers, which apparently you can easily, translate into your own reading file page numbers. So that's only one of several additional pieces of information that makes it very clear that OEWD thought DPW was running the show.
Okay, got it. Okay, thank you. Mr. Goldberg, you stated that you had contracted with one or two organizations to explore creating a GBD in the sunset. Was that before the community set their sights on doing that, or after the community's required first step?
I don't know. There was one grant, I believe, with Build Public or Place Lab to help the neighbors in the Inner Sunset to explore the possibility of setting up a GBD. I don't know what the timing of it was.
Okay.
I don't know which was the egg and which was the chicken.
Okay, because I think that's part and parcel to this particular discussion is where is DPW's involvement in the process. You've stated that for the current GBDs that exist, that DPW's responsibility is for monitoring, but that's after the GBD's been created. But your testimony was that you had contracted with one or two organizations to explore GBD prior to it. So where is DPW involved in this GBD process from soup to nuts or not?
I'm not really sure how to answer your question. I mean, I believe that in the past the department has had a policy of assisting neighbors who were interested in exploring the option of creating GBDs, because we would be the oversight agency if and when an actual GBD was approved by the voters and ratified by the Board of Supervisors, because we would have to follow the annual report. So I believe that our goal has been to help people who are interested in doing it. But again, the Inner Sunset one was they gave up. They decided that the neighbors decided not to do it, and that ended our involvement.
Well, that's like most of the other GBD attempts, Buena Vista and some of the others. The question I think here is, where does DPW's involvement begin? Does it begin prior to the community's exploration, during the exploration, after the exploration is done, and that they found positive support for it? I mean, where in the process is this happening? I think that is what the request, the petitioner here is asking for information for. Because you basically, I feel like in the committee meeting, based upon your testimony there, that you basically said you don't have any involvement in this at all when it comes to prior to the GBD being implemented.
No. I never said that. I mean, we've never denied being involved in GBD programs. What we said is that we, specifically on this request, is that we released to this group where everything we had, and we can't give them what we don't have. The degree to which our employee may have been involved in meeting with neighbors and helping organize community meetings I don't want to say it's irrelevant, but it doesn't have any bearing on our ability to, or our obligation to, get records that are not in our possession from an entity that we don't have a contract with. I mean, I have no ability to ask this outside organization. I don't have a contract. I can't threaten to withhold payment. I mean, obviously, my understanding is that the contract's over. But it's like when we get a records request and someone asks for 10 different categories of things. If I have records for 4 of them, I give them the 4. But if I know that Rec Park has the other 6, I send them to Rec Park. I don't try to get them from Rec Park for various reasons, if only for efficiency, but also because I have no control over Rec Park. And if I'm late delivering those records, I I have the ability to tell my own employees, you have to provide this for me within 10 days. I can't go to another department or an outside nonprofit that I don't have a contract with and say, you have to give me these things.
Actually, you can. Actually, under the Sunshine Ordinance and CPRA, one department can do that of another department, and one branch can do that of another branch, and it's happened before in the city. Sunshine Ordinance. Yeah, well, I have always been told the best practice is if I don't have the records, I have a duty to redirect the requester to the people who have the records. Correct. And that's what I do. Okay. Because as I said, I can tell someone in my Bureau of Street Use of Mapping, you have to get me this by Friday. We have a deadline. I can't necessarily go to a rec park employee and say, hi, you don't know me, but I'm telling you, you have to spend some of your work hours to get me records that I need. No, what I have an obligation to do is tell the requester, go to rec park. They have those records, and make the request of them, and the clock starts ticking when you make the request to them, and it's on them to get it to you. Got it. Okay. Thank you. Member Stein.
Yeah, so I'm not sure exactly how to word this, but the part that seems really unusual or problematic to me is that DPW is at least in part overseeing these programs, it's at least in part funding these programs, and has this connection to these private entities that aren't in any way seemingly formalized by any kind of obligation or contractual obligation. And I'm wondering, and I don't know what the other members of the committee think, but like Sunshine Ordinance 67.32 says that the city shall not give money and services to any private entity unless the private entity agrees in writing to provide the city with financial projections. Now, the city did contract with them, but the person who signed the contract was the OEWD, and yet it seems like it would have been proper if DPW was also a signatory to that contract, because it was also providing funds and services through the position of a program manager. So that's kind of like what I'm struggling with here, like why DPW wouldn't have been party to that contract.
Okay, so we one thing I just want to clarify, we cannot talk in generalities because this particular complaint was focused on the Mission Dolores GBD. And in the committee, Mr. Steinberg had stated that he had no records responsive to this particular GBD. So,
okay.
No, I'm so sorry. I don't mean to jump in. Just clarify. I didn't say we didn't have any records responsive to the GBD. We gave Mr. Hooper the 200 records we had, plus went into the 600 records that one of his colleagues had received in another request. What we didn't have were some of the financials and invoices and things like that, because again, we didn't hold the contract, and so we didn't get them. That's what OEWD presumably gave.
Okay, okay, got it. Okay, so correct. I'll stand corrected on that. That the records that they didn't have were the invoices. Whoever is making that noise, can you please stop? On the phone. Thank you. According to our minutes, Mr. Steinberg Steinberg stated Public Works does not have invoices as they do not have a contract with Parks Alliance, and assumes that OEWD, the contracting department, would have the invoices, which we heard about in the previous hearing. Okay, so Mr. Hooper, let me ask you now. That was part and parcel to your request from DPW, was it not?
Yes, I saw the obligation on the part of the city as coming from both agencies.
Hold on, I'm going to say something. Okay, go ahead, Mr. Hooper.
I have always viewed, because of my own experience in my own neighborhood, the Haight-Ashbury, I have always viewed DPW as really being more involved Jonathan Goldberg, incidentally, DPW still has a Green Benefit District Manager position, and I believe it's filled. So this is not all ancient history. It's still of some great concern. But in any case, DPW started sending out its GBD program manager about a year before anybody at the local neighborhood organizations, Hank or Coal Valley or Buena Vista, none of the established neighborhood organizations knew about it. And yet we later learned, there's one reason the whole thing fell apart, that Jonathan Goldberg of DPW was helping organize a kind of whole new group of neighbors, most of whom unaffiliated with existing neighborhood groups, and in fact, one might say in competition with them. So again, it's not giving you an accurate impression to say that, oh, we just sat around and maybe someone would give us a phone call and ask for some help. This was a very aggressive, in the Inner Sunset, in the Haight, and in Mission Dolores, it was the aggressiveness on the part of the city. This was not bottom-up percolating from interested neighbors who wanted to have cleaner streets. This was the city going in and campaigning actively, incidentally, I believe in violation of the city charter. But that's why people are so angry about this and want to understand it and have it stopped.
Okay, so Mr. Hooper, I understand that, and that is not necessarily in our jurisdiction per se. If we're able to provide some transparency that others might find that conclusion, that's not really what our purpose is for. I'm trying to focus on, though, Buena Vista is not Mission Dolores, and you're trying to make a comparison that, what happens in one potential GBD could possibly happen in another GBD, and you're doing your own investigation by asking for records. I get that. So, but the question here is for this particular GBD, we're hearing from the respondent that they don't have any responsive records with regards to invoices or financial records with regards to Mission Dolores. So the question I then have to you is, do you have any evidence that you provided as part of your complaint that that would say otherwise, that then we can ask DPW about?
Well, I think a couple of things. One is, I think the legal citation, City of San Jose versus Superior Court of Santa Clara County and so forth, make it clear that the city agencies own all that information. So the other thing I would say is in addition to grant money that DPW provided for these city-funded programs, they were paying a full-time guy. So I don't know how much money went to the city employee whose formal title is Green Benefit District Program Manager. That's certainly a piece of information that, even if Mr. Steinberg's contention that they don't know nothing about nothing concerning invoicing, they certainly know how much they paid.
Well, let me ask Mr. Steinberg, let me ask you this. Mr. Goldberg, let me ask you this. You had a fellow that was, I'm sorry, I'm getting your names mixed up. Mr. Goldberg was the one who was the employee? Is that right?
Green Benefit District Manager.
Yeah, Goldberg. Okay. So, Mr. Steinberg, Mr. Goldberg was in DPW's employ, is that correct? Hello?
He appears to have dropped off.
I don't believe he's dropped off. You accidentally muted him.
Did I?
Yes.
Hold on. There's a lot of noise coming from a particular disable. Oh, they're all disabled. Oh wait, up here. There we go. Okay, there we go. Are you there, Mr. Steinberg? Hello?
I think I just was able to unmute myself. Can you hear me now?
Yes, I can.
Okay, there we go. Sorry, my phone must have been making noises.
Yeah, it was hard to hear. So, my question again is, Jonathan, I think his name is Jonathan Goldberg, right?
Yeah.
Okay.
The former TV manager, yeah.
Right. So he was in DPW's employ, correct?
Correct.
And he was in DPW's employ during the Mission Dolores Green Benefit District potential formation.
Correct.
Okay. So the question Mr. Hooper is asking for now, you had stated to our committee you had no invoices with regards to Parks Alliance, but also part of his lengthy request was to find out if DPW was involved in the process prior to when the community had its responsibility. And was there any activation of Mr. Goldberg by DPW to involve himself in the creation of a Mission Dolores Green Benefit District and a formation?
That was never part of his request.
Okay.
I mean, he's insinuated a number of times, but and as I said, all I can say is, we gave him everything we had.
Okay.
Mr. Goldberg provided a lot of those documents, most of them to me. Other ones I had IT do searches, and I went through email to get additional documents. And that's all. I honestly don't know what Mr. Hooper wants us to do. We gave him everything we have. We don't have any more. We don't have a contract with Parks Alliance where we could ask them. But even if we did, according to what Ms. Thompson said, they don't have any more. I'm in circles for years on this, where I keep saying I don't know what else I can give him. Before he can make all sorts of insinuations that we're dark power behind the GBD cabal, but you can tell me a document that he thinks I have that I haven't given him. I'll give it to him. Yeah.
Okay. Thank you. All right, Member Stein, do you have something else? No. Okay. Okay. Anything else for the parties here on Discovery? I think we've spent quite a bit of time on this. Okay, let's move to rebuttals. Mr. Bill Steinberg, you have 3 minutes for rebuttal. I'll hand it off to Ms. Leger.
Sorry, David, you ready?
Yep. Tell me when.
Go ahead.
Okay, I really don't have much more to say than what I've been saying for 2 years, which is, again, we've complied with the task force instructions to provide all the records requested by Mr. Hooper that are in our possession. About 240 pages of documents directly, and then another 600 documents that we sent him a link to for a previous request for one of his associates. Yes, Kohrs Public Works is involved in GBD programs. We said repeatedly, what we said is that we have released to him, to Mr. Hooper, all the responsive records that we have. We don't have any more, and I honestly don't know what more we can do or what Mr. Hooper wants us to do, based on what is in our possession, our obligations, our legal relationship or non-relationship with Parks Alliance. I can't give him something I don't have to get. So again, I ask that you follow the complaint committee's recommendation to find no violation. Thank you very much.
Thank you, Mr. Hooper. You have 3 minutes.
Hang on.
Thank you, Mr. Chairman. Well, I would just say that because of the obligation under the contract itself, under state law. The city owns the work product of a third party, in this case, Parks Alliance. And Mr. Steinberg is asking what possibly more could I ask him to do? Well, I think a perfectly simple and straightforward thing to do would be for the appropriate person in his department, presumably I guess there's an acting head right now, to write a letter, or the modern equivalent, to the San Francisco Parks Alliance and say, having been an integral part of your various attempts to set up green benefit districts, we hereby are requesting you or requiring you to send in all evidence of payments you received under those documents, under those contracts. And, that would be responsive to, I think, to continually say we ain't got nothing or we've given you everything is to miss the point. That's the same as saying we don't have any obligation toward a third-party private contractor that we work with. And that's not what case law or city contracts themselves say. It's quite clear that, so I think it's not complicated. I think the Department of Public Works has a further obligation to demand of Parks Alliance the information that the public is very concerned about.
Are you finished?
I'm finished. Thank you.
Okay, thank you. Okay, members, the matter is with us for determination. Member LaHood.
Yeah, we keep running into this problem with third parties doing work for the city, and we know that they, by contract, are supposed to be providing information about their work to the city. They don't necessarily provide it. The city doesn't ask for it, and I don't, under the current arrangements, I don't know that we have the ability to reach farther, even though I understand the frustration expressed here by the petitioner, because this is not just with this entity. This comes up across the board in so many other situations. And is there anything we can do? I don't know. I'll hand it off to.
Okay, so go ahead, Vice Chair Yankee, and then Member Stone.
Sure. To start with, I totally share Member LaHood's frustration. This is something we see come up over and over again. In this case, though, I think part of the frustration here with these GVDs is that it seems to be two departments that are involved. Sometimes one has a contract, sometimes it's the other. And so I think Chair Wolf brought it up earlier, though, and I think is what's kind of focusing me on this case is that even though one agency or department in the city may have had a contract in other instances, we have to focus on this particular one. And I think it's been established in this particular one that it's OEWD that has the contract with Parks Alliance. And so it's the question on this one is what more can DPW do, specifically because they don't even have a contract with Parks Alliance. OEWD does, and that was a lot of what I think the problem was in the prior case we heard. But I think DPW's hands are pretty much tied for getting anything more than what they already have. That's why my first question on this was, do they even have access to the financial system on this? And Mr. Steinberg said they didn't. So I'm having a hard time seeing what more at this point DPW can give. Obviously, in the prior case, there was more information to give. I just think in this one, it's, for whatever reason, OEWD is the one that seems to be holding this particular contract or this particular set of information that, at least for the finances, that remain outstanding. But I totally share the frustration. It seems that a member of the public trying to find this information, it's like a never-ending maze. And we've all been on this, and there's how many people on this task force, and here we are 2 years later, and we're still kind of confused about it all. But I'll leave it there.
Member Stone?
Yeah, I'll just say I pretty much agree with both of the members that spoke ahead of me. And I just want to mention, in response to what Member LaHood said, that in the kind of state of the art or what's considered best practices in freedom of information law now around the world,
Many countries now require that any private entity that is subsidized in any substantial amount by the government is subject to the freedom of information laws that also apply to that government. And this might be something that we want to recommend to the Board of Supervisors as an amendment to the Sunshine Ordinance. That's my comment.
Thank you. Member Schmidt.
Yeah, just right on that same point that you all have been on. You know, I don't know if I buy the idea that, okay, I didn't actually sign the contract, so therefore I'm out. You know, like I don't have any need, even though I work constantly with this Parks Alliance, day to day. We meet all the time. But no, they don't have to do anything if I ask them for all the documents. I don't know if that's true. I don't think it's that like clean cut. And I know that Mr. Steinberg says I couldn't do anything else. I couldn't ask him. I couldn't force him. I don't think so. I don't think that's true. And the law says that, you know, the city's got an obligation to go to Parks Alliance. And so, you know, Mr. Steinberg says, well, it wasn't me, but I was told that someone else was doing it. So how could I do that? I don't buy it. I'm not sold. And I think that Mr. Hooper is on to what I think is a violation in this situation.
Anybody else? Okay, so I'll say this. OEWD is a department and DPW is a department within the executive branch. This is all part and parcel to city and county government within the same branch. The contract with regards to Parks Alliance, the executive branch has multiple contracts with Parks Alliance, as we know, not just with DPW and OEWD, but with various other departments. It's now a well-known fact. So as far as I'm concerned, they have an obligation. Now, asking for, I would say the executive branch has an obligation to produce the information. Okay? Somebody has a contract with somebody, and somebody has a contract, that contract has a purpose for producing some sort of outcome or some sort of labor or some work. Okay, there is an office of contractual of contracts through the city administrator's office. The controller is the one who cuts the checks. They obviously have a contract. Everybody has their hands on this contract at one point or another. It doesn't really. It's the purpose of a requester asking one department or another for records is for corroboration lots of times. And sometimes one department actually doesn't have the information, and they then try to help the requester find it through another department that may have it. That is a requirement of the Sunshine Ordinance. Absolute requirement. Okay? So that's the first question that we have to answer. Okay? The second question is for this particular request, it does it or does not rise to a violation. It doesn't mean that there may not be a problem or there may not be some concern about it, or it may be something that we want to take up and investigate ourselves based upon, is this a shell game where at any one point somebody says, okay, for this community, this Green Benefits District, OEWD, you do this one, and then this other Green Benefits District, ODPW, you do this one. Okay? I don't have necessarily any evidence of that, but if records are being requested by members of the public and the public finds out about something like that, then, then that's on the public to do. Our job here is to determine, are there records, are they being withheld, If they are they being withheld properly or not? And it will asking any of our questions or bringing out some sunlight in our hearings here will start to reveal certain things. Okay, our job is not necessarily to root out any problems. If we notice that there are problems based upon our findings, yeah, we should report them, absolutely. So I just want to say that if this particular request on DPW does not, rise because there's the records that were specifically being requested don't exist for this particular department, for this particular activity, then okay. Another request could be asked by a member of the public for a different department that might have involvement, and they might get satisfactory results. Member Schmidt, do you still have your hand up, or do you want to say something else?
Yeah, one thing I forgot to include is that I am very, I really am suspicious as to really whether all these, whatever the documents that Parks Alliance would have, and none of us knows, but that's not as important as knowing that they might have things, and so the approach has to happen. There has to be somebody from the city who goes to Parks Alliance and says, you got to give us things. And I would think there'd be a paper trail for that contact too in this situation. Now, I'm really suspicious as to whether anyone, even at that other agency, OEWD, really did that. And I think that tonight was the first time I ever heard anyone say that they did it or they even thought they had to do it. So that's why I'm not sure if I would rely on that for thinking that, anyone at the city helped Mr. Hooper out with Parks Alliance.
Okay. I'll get to you in a second, Vice Chair Yankee. Just in response to that, Member Schmidt, I would say the request is not being made of Park Alliance. The request is being made of DPW. If DPW, and we've had these cases before, where people have brought requests similar to this from the department says, I don't have those records. Okay? So the next request that's made when the petitioner gets that response from us, and we find no violation because they don't have any records, then requester then goes out and makes a request of the contractor itself. Now the question here is this a nonprofit organization that is covered under 12L, or is this a contractor with the city? There's a big difference, okay? A nonprofit that receives, let's say, a grant for managing, let's say, a building, would and they operate it unto themselves. We've had this case come up for the Bayview Opera House. Then that's a 12L issue. But if a contractor, for-profit, nonprofit, doesn't matter, if they are providing a specific function and service for the city that the city would normally have staff for, and they're actually doing that, like filling potholes and things like that, then they are a contractor. It's not a 12L issue. Go ahead, Member Schmidt.
I half agree. I think that the member of the public can go to the nonprofit and ask them for documents, and that's one procedure. But they don't have to do it just that way. They can do it this way.
I get
go to
that.
The city, and the city goes to anyone who has whose records they have what's called constructive possession of. And so the citizen goes to the city and says, here, you go get those for me, because I'm entitled to that under CPRA and under Sunshine. You do it, and you take care of it for me.
I get you. I understand what you're saying. I do. And you're saying that the department should go the extra mile to get the records from their contractor for the work that they've been contracted to do, right?
You could call it the extra mile, or I'd say it's still within the first mile.
Well, we've had problems. I mean, this goes to a lot of different things. I mean, there are, for another example, right here in the Haight where I live, there were problems with construction in the street. Okay, and when information was requested from DPW about the contractor, there was no responsive records until the contractor was contacted directly. Okay, so yes, I get you. The question is for perfect sunshine and transparency, every piece of information from every fingernail, grain of fingernail, should be in the possession of the contracting agency. I get that. Doesn't always happen. Vice Chair Yankee.
Yeah, I was, mainly going to echo what you said earlier. To me, in this case, this case is frustrating and it's difficult because it involves, there's a third party, Parks Alliance, if not more, third parties. There's multiple city agencies involved, but I think we need to focus in on this particular case, and it's with DPW. In my opinion, in this case, there's looking at 6721. Did they give records over? Yes, we know that DPW gave hundreds of records over that they did have in their possession. Obviously, it wasn't everything that Mr. Cooper was looking for. So did they then fulfill 6721C to assist the requester in identifying the other department that may have them? In this case, I think they did. Mr. Steinberg, talked about referring them back to OEWD. OEWD testified here that they did reach out to Parks Alliance. I think it was telling that when Mr. Heckel responded with the missing records that for 2 years, they wouldn't turn over, he did so on behalf of OEWD. He did not do so on behalf of DPW. He specifically wrote that I'm responding on behalf of OEWD. So I'm not sure what else DPW can do in this particular case. It sounds like they turned everything over and made the referrals to the other places where records may exist. In fact, they did exist there. We just heard that in the prior case. So I kind of the same place I was at the committee level, and I don't see a violation here.
Well, I would say also that the executive branch is the primary responsibility is the mayor. And nothing happens without whoever the mayor is in any year. They have full control over decisions that are being made in the executive branch, unless they give away that authority to somebody. And so while we're trying to meander between one department and the other, or I should say the requester is trying to meander, and we're trying to help fulfill the retrieval of certain public records. If they aren't available in one file cabinet, then somebody's got to keep looking. And I think we've been round and round with this enough. I don't see anything that necessarily points to, for this particular issue around the Mission Dolores GBE, that DPW has any involvement with it. that instead it was through OEWD, through their contract with the Parks Alliance. I'm not saying that there isn't any involvement, because DPW has admitted that they are positively involved in Green Benefits District, but that's, in one case for one Green Benefits District, but not this one. And they're involved in it once the Green Benefits District gets formed, after the community effort. So leave it at that, and we'll enjoy a motion, because it's 10 o'clock.
Yeah, all right, this is Vice Chair Yankee. I'll go ahead then, at least to move this along, to make a motion to find no violation against public works for 6721.
Is there a second?
Member Highland, I'll second that.
Okay, moved by Vice Chair Yankee, second by Member Highland, to find no violation of
6721.
6721. Okay, any further debate or discussion? Let's open up public comment. I'll hand it to you, Ms. Bishop.
Do we have public commenters?
Yes, please.
Okay. Do we have other public commenters?
Anonymous number 3 after Mr. Warfield.
Okay. Anybody else? Okay, Mr. Warfield.
You'll give me a 30-second warning and let me know when to start, please.
Yeah. Go ahead.
This is Peter Warfield, Executive Director of Library Users Association. You can be reached at libraryusers2004@yahoo.com and at PO Box 170544, San Francisco, California 94117-0544. Thank you for a very interesting discussion. First of all, again, I want to say that your agenda packet does not have, your agenda online does not have any link to the documentation for this. And that's certainly a problem for informed public comment. This was a very interesting discussion. So let me just point out key elements here. 67.21C says a custodian of a public record shall assist a requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, and so on and so on. Available to, that seems to me to include a department or an agency of the city being able to say to somebody they're working with, you have blah, blah, blah records. We would like to see a copy. I also appreciated a member, I believe it was LaHood, who talked about elsewhere what the practices are. And section 67.29-6 is a very interesting one that I think has very little, to my knowledge, been used. But it refers to sources of outside funding, and basically has such kind of a provision with respect to folks giving money to an agency or official. And what it basically says is, no official or employee or agent of the city shall accept, allow to be collected, or direct or influence the spending of any money or any goods or services worth more than $100 in aggregate for the purpose of carrying out or assisting any city function, unless the amount and source of all such funds is disclosed, and so on and so on. And it says, when such funds are provided or managed by an entity and not an individual, that entity must agree in writing to abide by this ordinance. The disclosure shall include the names of all individuals or organizations contributing such money and a statement as to any financial interest the contributor has involving the city. So I think you may very well have something that should make you vote no on this. That is that records are available to the respondent. Thank you very much.
Anonymous, you ready?
I am.
Okay. Go ahead, please.
Thank you very much. This is Anonymous number 3. There's one misunderstanding and another misconception, and for those reasons you need to vote no on this. First of all, the 9 original requests made by Mr. Hooper to DPW include Mission Dolores and Greater Buena Vista, not just one of them. And then the other part is the discussion that's very accurate that Member Schmidt has made about the obligations under Community Youth Athletic Center versus City of National City, where the city is obligated to properly instruct its contractors. And if it doesn't do so, its unwillingness or unableness to do so is equivalent to withholding that information from the public. And so that proper instruction hasn't occurred here. The question of whether DPW, in this request, in this contract, is involved can be answered by those supplemental records, actually, that OEWD gave me and Mr. Sullivan and Mr. Hooper. In that, there's a January 16, 2019 email from Parks Alliance to OEWD. They have deliverables for Greater Buena Vista, Dolores Park, and Inner Sunset. That thread goes on to say that gets, I'm going to read it to you. I have reviewed these and spoken with Jonathan. Jonathan is Jonathan Goldberg. Quote, they meet public works needs for the GBD program. Please submit this approval email with your submission to TGS. That is OEWD telling Parks Alliance that they reviewed the records with with Jonathan Goldberg, the public works employees, and quote, they meet public works needs for the GBD program. In this contract, in this request, DPW was extensively involved. In fact, they were the ones reviewing the so-called, quote, funding request deliverables from Parks Alliance through, for some reason, they get funneled through an employee of OEWD first. So I would urge Member Schmidt maybe to explain more about Community Youth Athletic Center. I think it absolutely applies here, and I urge you to vote no. Thank you.
Any other public comments?
Yes, hi, this is Mary Ann Thompson from OEWD, and I would like to make a public comment. Thank you.
Are you ready?
Yes, I am. Thank you.
Go ahead.
Okay. I think you are right in not finding DPW in violation. I think it's really important to understand two things. DPW and OEWD worked together to respond to Mr. Hooper's request. OEWD did indeed provide Mr. Hooper with the contracts with the Parks Alliance and with the deliverables. It also needs to be made clear that the funding for the Mission Dolores Greater Green Benefits District was funding that was given to us from a previous supervisor, and that's why that contract went through OEWD's office. It was an add back that came from the District 8 supervisors. And finally, I'd like to point out to everyone here this evening that Mr. Hooper, who claims he has no access to technology, tonight has been citing the emails he received from Mr. Henkel to support his argument against Mr. Steinberg. So he either did or did not receive the emails from Mr. Henkel, or he is somehow finding these mysterious documents. So I would like to point this out to you, that he's quoting emails that he said to you, in my case, that he didn't receive and he wasn't able to open. So I'm not sure where he got this information. And that's my final comment.
Any other public comment?
Mr. Chairman, John Hooper, may I just correct the record?
No. I understand that that something may have been said that you may not agree with, but I can't allow a debate from a party, a public commenter.
That's fine.
Okay, thank you. Okay, members, I will say this. I'm reading on page 2126 of item 9, part 1, PDF. This is the original request dated February 11th, 2019 to OEWD Public Works, Rec and Parks Alliance, and the organizing committees of Greater Vista Green Benefits District and Mission Dolores Green Benefits District, the formation committees. Okay, and the requests are made from all of them for the original, what started out being 9 requests. So what's ended up happening here is that the complaints were brought independently of each department at this point. And so I'm just listening to what folks are saying. I hear that the department has provided all that they think they have, or they know that they have, that there is some concerns from task force members and from the petitioner that there most likely is more. I hear from one of the public commenters that, citing case law, that that the information is to be treated from the contractor itself, is to be treated as such. And frankly, there is actual verbiage in the Sunshine Ordinance that is specifically to be used in every contract. And I know, because I'm on the board of directors of a nonprofit that receives city funding, and there's all kinds of Sunshine Ordinance requirements in those contracts. So, you know, I think that there is some obligation here. I'm not, while DPW may not have the records in their hands right now, I am compelled by another public commenter's reiterating 6721C, and I think that that is compelling to me, that a custodian shall assist a requester in identifying the existence, the form and nature of any records or information maintained by or available to or in the custody of the custodian, whether or not the contents of those records are exempt or not. So it's the question is the question here on C is a little, it's not quite as expensive, because it's whether it's maintained, available to, or in the custody of the custodian. Are any of this information with regards to contracts with Parks Alliance available to the custodian? I'm pretty sure if DPW went to Parks Alliance and said, hey, can I see your invoices from OEWD, that they would probably give it to them. Okay, I think Member Schmidt was implying that that should be done. That should have been done. This is all part, again, I'd say this is all part of the same executive branch. Because the request is being made of each and every department that didn't comply or didn't, that were part and parcel to this, that may or may not have records, is, you know, sure, it may be considered a fishing expedition, but okay, you're going to get some records from one department, you may get the records from it, you might not get records from another department. But I think the real focus is on the contract is with the city, okay? And the question is who has full control and access to that contract? Because if Parks Alliance is providing a service to the city that it would normally have staff do, then again, it's like filling potholes. That anything that is within the jurisdiction of that contract is public information. So versus, as I explained before, receiving like a grant or funding to operate a third-party operation of some sort, that doesn't provide a direct benefit to the city government or as a service to city government. So I'm compelled by this in a way, and I'm a little torn about which way to vote on it because of that. So I'll just stop there, Vice Chair Yankee.
I absolutely understand where you're coming from, and I'm sure everyone's kind of torn on this. I think, in fact, and I forget when it was mentioned, but there was a chain of communication brought up not too long ago about something in the contract being approved, and I believe it went from Parks Alliance, the communication, to OEWD. OEWD then went and checked with DPW. DPW responded back to OEWD, and presumably OEWD then communicated with Parks Alliance, the contractor, right? So I think this demonstrates to me that it's OEWD and Parks Alliance who are the two parties in communication with each other. It showed that Parks Alliance wasn't, in this case, reaching out directly to DPW and saying, hey, did this fulfill things? No, they went to OEWD. OEWD forwarded that to DPW for approval. We all know both departments are involved in it, but so the question is, can DPW directly go to Parks Alliance? And not just could they, but is it a violation of the Sunshine Ordinance if they didn't? Maybe they could have. They could have asked potentially, but does it mean they violate the Sunshine Ordinance? I just don't see that, because they knew OEWD was in communication with Parks Alliance, because we saw those emails showing that OEWD and Parks Alliance were the two parties in communication with each other. And so I don't think it's a violation on DPW's part to refer those requests back to OEWD. So I'll just leave it there. I know it's getting late and I should wrap this up.
Okay. Member LaHood.
I'll make it quick. I agree with Chair Wolf. I think it was definitely available to if they had taken the additional step of asking for it.
Okay. Are you ready for a vote? Okay. Please call the roll.
Okay. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Member Highland
No.
seconded it.
Sorry, Member Highland. I apologize. Member Highland?
Aye. Aye.
Member Padmanabhan? Nay. Member Padmanabhan, no. Member Neighbors?
Nay.
Member Neighbors, no. Member Stein?
Nay.
Member Stein, no. Member Forsley, absent. Member Schmidt?
Nay.
Member Schmidt, no. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
No.
Member LaHood, no. Chair Wolf?
No.
Chair Wolf, no. 1, 2, 3, 4, 5, 6. The noes have it.
Okay. I'd like to make a motion to find a violation of 6721C and order the DPW to request such records from Parks Alliance that may be available to them because they currently have contracts with them and access to them, and for this to be referred to complaints and amendments for monitoring. Is there a second?
I'll second the motion.
Who was that speaking?
That was Member LaHood.
Okay. Moved by the Chair Wolf, second by Member LaHood, to find a violation of 6721C and to order DPW to assist the requester in identifying and you can take it right from 6721C. Assist the requester in identifying the existence, form, and nature of the records that the requester is requesting, and or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days following the receipt of the request. Well, actually, in this part, I would say, let's give it 2 weeks, okay? Because I know everybody's trying to get back into their offices and get back to work. So give it 14 days, and compliance and amendments will monitor. Okay, public comment.
Sure.
Hang on a second. Lila, you were the second? Is that correct?
That's correct.
All right. Do we have any public commenters?
Gary?
Yes.
Okay. Do we have others?
Yes, anonymous number 3.
Okay. Mr. Warfield, you may begin.
This is Peter Warfield, Library Users Association. I'm happy to hear this motion being made, and I'm happy to hear Chair Wolf's comments as well as the others that were commenting on this motion. I guess it's looks like it's going to be the reverse in terms of yeses and nos of the previous motion, which was for no violation. This is for a violation. I'm glad it's going to compliance. I'm glad you have a time limit. Excuse me. So yes, I think this is absolutely a yes vote, and basically cuts through attempts and practices of basically baffle gab and sending people running around in circles because on some technical level you haven't got the goods in some file drawer or in some database or something like that, which shouldn't be done to folks who in good faith are seeking information. So thank you for the motion and certainly support it. Thank you.
The second anonymous will be right with you.
No problem.
Are you ready, sir?
I am.
Go ahead.
Thank you very much. Agree with every single point Mr. Warfield made. This is going to be a hard motion. It's going to require all 6 votes that were no on the last one to be yes here. Otherwise, I believe if there's no motion, Mr. Hooper loses by default. And so I'm going to give you some more reasons why you should vote yes. This is the Appendix B, definition of grant plan from an OEWD supplemental record provided as we discussed in the last hearing to me. It has project definitions. There's a term called Cities Team. It has 3 members: Christopher Korgis, Senior Program Manager, OEWD, Jonathan Goldberg, Program Manager, Public Works, and Helen Marr, Project Specialist, OEWD. It mentions 2 project areas surrounding Buena Vista Park and Dolores Park, and it mentions Inner Sunset GBD. The Public Works is integrally involved they are part of the, quote, city's team, a defined term in the appendix of the grant plan. They should, and not just under the Sunshine Ordinance. To be clear, I, of course, believe the Sunshine Ordinance requires them, but I'm saying even under the weaker CPRA, courts have found that they should properly instruct their contractors under Community Youth Athletic Center versus City of National City. And so you absolutely should vote yes. This is finally a way to cut through how do you get at the contractors. And I urge you to vote yes. Thank you very much.
Any other public comment? Last call, public comment. Okay, public comment is closed. Members, anyone? Any last thoughts? Are we ready for a vote? Okay, please call roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley, absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
No.
Member Highland?
Aye.
Member Highland, aye. Moved by Chair Wolf, second by Member LaHood, to find a violation of 6721C and order DPW to assist the requester in identifying the existence, form, and nature of the records the requester is requesting.
Yeah.
Can I ask for clarification, please?
Who's speaking?
This is David Steinberg.
Yes.
I just want a clarification. Exactly what records am I supposed to ask Parks Alliance for? Presumably not the same ones that Ms. Thompson already asked and they said they didn't have, but is there anything specific I'm supposed to be asking for?
I believe it's the financial documents. The ones that you said that you didn't have.
The ones that Ms. Thompson already provided to them. Okay, thank
you. Mr. Steinberg, I just want to say that just because one department provided it to somebody doesn't mean that you're absolved from it. Okay?
Yeah, I know. That's why I redirected them to OEWD.
I understand that. But the records that were provided at the time of the request, not now, but at the time of the request, that's what we're talking about here. This is happening in the period of time that the request was made and not fulfilled.
Okay, I will ask them for that.
Okay, thank you.
Thank you very much.
Thank you. Thank you very much.
One more notation about the motion. I did not include that the request must be fulfilled within 14 days and refer the matter to compliance and amendments to monitor.
Right, thank you. Okay, let's go. And I just wanted to note there was a public commenter about not being able to download the items from the agenda. Underneath the description, there are a list of the parts of each for each item. Those are the links that are there. And yes, probably there should have been some directive there that these are the links. Click here. I just wanted to notate that for everyone. I know that was it's a little off the reservation than what we usually do, but that's how this was set up. Okay, let's go to the next item, please.